Good morning, everybody. Can I welcome members, invited guests to this morning's Police and Crime Committee. Particularly thank you and invite and welcome members of the public. We have a better turnout than we normally do. Welcome colleagues and friends from Tower Hamlets and elsewhere. So thank you for coming along this morning. Members of the public who are not here may wish to follow us on Twitter at London Assembly and hashtag Assembly Police. Our main item of business today is to discuss tackling allegations of electoral fraud and malpractice, but we've got a few pieces of formal business beforehand before we get to the main body of the meeting. So first of all, item 1, apologies for absence. Can I ask if we have any apologies for absence?
Thank you, Chairman. Apologies have been received from Assembly Member Badenoch and Assembly Member Arbour is substituting for her today.
Thank you so much. Item 2 is declaration of interest in the normal manner. Can I ask the committee to note the recommendations in item 2 and ask Assembly members to declare any other pecuniary interests that are not noted? Thank you very much. Item 3, can I ask the committee to confirm the minutes of the meeting of the Police and Crime Committee on the 12th of January to be signed by me as a correct record?
Agreed.
Item 4, can I ask the committee to note the completed and ongoing actions arising from previous meetings of the committee? Thank you. Item 5, can I ask the committee to note the recent action taken by me under delegated authority following consultation with group leads and Caroline Pigeon, namely to agree the arrangements for today's meeting. Item 6, response to violence against women and girls. Can I ask the committee to note the response from the Deputy Mayor for Policing and Crime to our letter on preventing extremism as attached in the Appendix 1 to the report. Thank you very, very much. Right, that takes us to the main item for this morning's meeting, which is tackling allegations of electoral fraud and malpractice. The meeting today is split into 2 parts. For the first part of today's discussion, we are going to focus on the role of MOPAC, the MPS, the Electoral Commission and the Crown Prosecution Service in tackling allegations of electoral fraud and malpractice. So can I welcome the guests, and we are blessed with many guests today, and I'll just run through them. First of all, for the Met, with Detective Inspector Gal Granville, Commander Stuart Cundy, Robin Merritt for MOPAC, Claire Bassett, Chief Exec Electoral Commission, and Nick Vamos, Head of Special Crime CPS. And welcome all to that meeting. So I shall start the first set of questions, if I may, which is the broad title of tackling allegations of electoral fraud and malpractice. And again, I welcome everyone to this morning's meeting. I will put on record initially the committee's disappointment at the early reluctance of MOPAC to come along, and so I'm delighted that Robin is here today, but there was some hesitation. And bearing in mind the Deputy Mayor's letter about the importance that she attaches to this issue, it seemed rather odd that MOPAC were reluctant, but you're here now, and that's the most important thing. So my first question to all of you, and I'd ask you to be relatively brief if you could, is, speaking for your organisations, what is your role in tackling allegations of electoral fraud and malpractice? Whomsoever may wish to pipe up first.
I don't mind going first, if I may, Chair.
Thank you.
So from the police perspective, and of course this is not unique to the Metropolitan Police, but no, that is pertinent to what we're here to discuss today. Go back to the original principles of policing. So in relation to electoral fraud and malpractice, two key roles for us as the police. The first one is to prevent electoral fraud and malpractice, and we do that in conjunction with partners, some of those that are here today in this session, but also clearly, secondly, to investigate criminal matters that are then reported to us. Now, the key thing for us as a police is that operational independence and clearly neutrality in what on occasions can clearly be challenging situations, whether it's a local or a general election. Now, we as the police, nationally, you may have heard of authorised professional practice, which is authorised by the National Police Chiefs Council, which, when it comes to electoral matters, is done in conjunction with the Electoral Commission. We have the APP, which is issued to all police forces. which I say is guidance on the best professional practice that is constantly evolving, was most recently updated in the middle of 2016. And the lead for that is an Assistant Chief Constable, Gareth Khan, from the West Midlands Police. When it comes to investigations, I'm sure we'll talk more about planning and how we can go about preventing electoral fraud and malpractice. When it comes to investigations, clearly we would approach that as we do other investigative matters. We will always need to follow the evidence. We will always need to be neutral when it comes to some of the issues at hand. And undoubtedly we'll talk more about that in this session, indeed part 2, when we talk about town hamlets as well.
Yeah, well, we will pick up on that in slightly more detail in the case study, but you've confirmed that it's preventing and investigating fully.
They are the two hallmarks of all aspects of policing, but particularly relevant when it comes to electoral fraud and malpractice.
Okay. Robin, how does MOPAC sit into at a strategic level?
Clearly, our role as MOPAC is one of to oversee the efficient and effective running of the Metropolitan Police Service. So that's our role. Regarding electoral reform, I think we have obviously a generic role as being part of a democratic body that, we are take all matters of electoral procedure and the smooth regulation of elections seriously. And when something happens which is of particularly high profile to question that electoral process, that matter would receive specific oversight. But actually, in terms of our responsibilities directly to the electoral process, I think it's purely one of overseeing the police and effective running of that.
You put that in two parts. You put with the mayor's interest in the electoral process within London.
Yes.
But also, and the other part is the mayor MOPAC's duty to oversee the performance of the Met around investigation and performance.
Yes.
And that is something that we will pursue later, because we have obviously got the Deputy Mayor's letter to us in response to the request around that. And as will be aired earlier, this has been discussed and scrutinised by under the previous Mayor as well, particularly under the case study later, which we will pursue, and as to the effectiveness of MOPAC around that.
Yes.
Claire?
Yes, so at the Commission, we have a broad role in supporting, providing guidance and training and practical advice, both for returning officers and for the police. Stuart's just given a good example there of some of the information and things that we feed into and we do jointly. And indeed, I work very closely with Gary Cann. We were together on Friday having a training session for police from across the country. So we have an important role in making sure that the approach is taken as the right one, of monitoring the approach of returning officers and providing support where they need it. We also have a broader role in gathering data and information about fraud, and we are the only people that do pull that together and publish that at a national level. What we don't do is investigate individual allegations of fraud. That is not the remit of the Electoral Commission, and I think an area where there is sometimes confusion, that it's anticipated that we will play a more active role in a particular allegation or investigation when we would in fact refer that to the police.
Okay. I mean, there is a government review around the whole piece around this, which you'll be aware of, which does slightly change and nuance some of the roles, I believe.
But it doesn't say that it expressly doesn't address that. I mean, it leaves our role as it makes some recommendations around the nature of offences and things like that, but it does not suggest in any way that we ought to have any investigatory function.
And that's probably quite important, isn't it?
Yeah.
Nick, you got any thoughts around your role in this?
Yes, thank you, Chair. Crown Prosecution Service has, on one hand, a more limited role, but on the other hand, a more focused and sort of sharp-edged role. We're the authority with responsibility for bringing prosecutions for election offences in England and Wales. To the extent that we bring those prosecutions, we're dependent on the police to investigate and produce the evidence, but then we make the decision whether that case should go to court. And if it does go to court, we prosecute it and see it through. The one thing I would add to that is that though the term election fraud is a convenient umbrella to discuss these kinds of offences, it's something of a misnomer, because many of the offences under the various acts don't involve dishonesty. They can be of a technical nature. Some do and some don't. So I just wanted to make that point.
Okay, thank you very much. We'll revisit all of those points as we continue on. Now, going back to Stuart and to D.I. Gower, about the process. Could you just tell the committee what is the process for investigating issues referred to your special inquiry team. And talk to us a little bit about the special inquiry team as well when you respond.
Yes, of course, Chair. So the special inquiry team within the Metropolitan Police is a small team of specialist detectives, 7 detectives, and they perform our single point of contact role when it comes to electoral fraud and malpractice. And every police force has that SPOC, to use the acronym, function within every force, and that's what the special inquiry team do for us. So within London, that team of officers are the team that investigate all matters that pertain to electoral fraud and malpractice. We don't allocate them to local investigating officers, and one of the main reasons for that is very much the specialist nature and the unique nature a lot of the offences that are being investigated. In terms of the oversight of that team, so Gail, who's here with me today, is the detective inspector responsible for that. It became part of the portfolio that I'm responsible for in the Met, which is specialist crime investigations, in 2013. Before that, it used to be part of SO15, which is our counter-terrorist command within London. So that team, working closely with the Electoral Commission and others, has built up a considerable body of expertise from London. The conference that was alluded to on Friday last week, we, along with representatives from other forces, are always party to that conference. In terms of the process, when the referrals are received by us, so we record from the Metropolitan Police any type of referral. Some of them will not be criminal offences when they're referred, but we will record every single referral that comes into us as the Metropolitan Police. A proportion of those will subsequently be recorded as offences, electoral fraud and malpractice, and it's those cases which we refer on a monthly basis through to the Electoral Commission. In terms of the investigative process, we will follow the, if I can use the phrase, a normal investigative route, which will be about identifying who the complainants are, trying to secure and preserve evidence, identifying who suspects and offenders are, and then taking each of those avenues where the evidence may take us to try and establish, firstly, has an offence been committed, and if an offence has been committed, who is the individual or individuals responsible. As part of the unique nature of these types of offences, we work exceptionally closely with the Crown Prosecution Service. So the team that works for Nick are within the CPS, and Nick will talk more about this, I'm sure, have specialist lawyers that have expertise within this particular area. So as part of an investigation, we will have continual engagement with the Crown Prosecution Service, who will assist us and provide us with advice on investigative opportunities that are worth pursuing. And that does occur in cases where they identify some and say, you might want to get advice from the Electoral Commission on this particular point. And that's what we call early investigative advice. Within the criminal justice process, when we as the police are satisfied that we believe we have sufficient evidence for a decision to charge, we will then do another formal submission through to the Crown Prosecution Service, who are the decision makers about an outcome, about whether an individual will be charged or indeed cautioned, or indeed within this offending, some individuals will receive warning letters or words of advice from us. And all of those, what are termed within the Home Office positive outcomes, the expectation within the authorised professional practice I referred to earlier, we will never make those decisions alone as the police. We will always work with CPS, consult with them before making those choices being made.
I mean, when we get to the second half of meeting the case study, we look at allegations against disposals and how that process is connected. So as you said yourself, your unit, your team sits within SCO1, which is your lead and portfolio.
That's right, Chair. So my portfolio, I have two main commands. So SCO1 is the Homicide and Major Crime Command, of which the Special Inquiry Team is one part of. So whilst the team is relatively... So
does it sit naturally in that sort of grouping?
It does. So my whole portfolio is basically the serious and major crime, primarily reactive investigations for the Metropolitan Police. So everything from rape, serious sexual offences, through to homicide and these types of offences as well.
Okay. We've had suggestions from others about potentially other ways of approaching this, but that can be investigated later when we talk. Now, turning again to MOPAC, we touched upon earlier in the introduction. So specifically, how does MOPAC assure itself that the Met is investigating issues such as electoral fraud effectively?
Well,
I suppose 2 points really. One is, the actual conduct of investigation is clearly a matter for which the police have operational independence, and we wouldn't seek to, direct or control any investigation. As part of our work around ensuring the Metropolitan Police is fit to serve London, we are clearly kind of have oversight of their performance in terms of, headline performance. We look at the skills and capability that are within the Metropolitan Police Service and do considerable work around that. Clearly, there are different levels of oversight as well. So in terms of the recent work around vulnerability, we know the Deputy Mayor's, taken that matter and chairs a personal meeting which oversees performance against the HMIC recommendations to a considerable level of depth. Regarding other level inquiries, we'll be looking at, say, the workforce and actually have the Metropolitan Police got the right number of skilled detectives in the right places to perform that function. So not specifically looking at any individual investigation, but we will look at the capability and capacity of the Metropolitan Police Service to respond to the demands within London.
I mean, without straying into the second half of the meeting, this has always been a tension of whether the Mayor and the Mayor's office should busy itself with individual pieces of work that are clearly in need of scrutiny, or stepping away and looking at it strategically. But we'll look at that around a case study. Caroline, did you want to come in? And
I
then
just
Andrew?
wanted to ask the Commander, you said you had a small team of specialists. How many people do you have working in that small team? You haven't given us any context.
No, so I think I mentioned earlier, so there are 7 specialist detectives working in that team.
7?
Yeah, so it's 7. Their responsibility extends beyond electoral fraud and malpractice into other very sensitive and specialist investigations. But they are part of a much broader command, which is the SCO1 Homicide and Major Crime Command. So, indeed, I'm coming to the case study later, we have the ability within my portfolio to flex additional, well-trained specialist detectives to assist who won't have the same level of expertise when it comes to electoral fraud and malpractice as the Special Inquiry Team, but are trained, well-trained investigators to assist those investigations.
You've got 7 specialist detectives who are really experts in all aspects of electoral law and know it inside out and about electoral practice and how it all works, and they are the ones across London who would be investigating any allegations.
So their primary function is to investigate. They are not lawyers. They are not experts in all aspects of electoral matters, clearly, but they work with other experts like returning officers, EROs, etc., Electoral Commission. But their primary role is one of investigation, but they will have the higher level of knowledge when it comes to electoral fraud and malpractice.
Well, I just say we were at the Electoral Commission's training on Friday with the spokes from around the rest of the country. So we go to the annual training twice a year.
And what other things are they working on? So they don't just do electoral practice. What other things they do?
So the investigations will include investigations into members of Parliament, MPs' expenses, into particularly sensitive inquiries, where we've got a high level of expertise in terms of some of those more delicate investigations as well.
Okay. And then I had wanted to just follow up with Robin from MOPAC. I'm not sure I clearly understand. Has MOPAC in general done anything to look at the issue of electoral fraud and how the Met operates in that field since its establishment?
Not on a generic basis, no. Not as far as I'm aware, but certainly there was oversight of this matter, and this matter did get discussed between the Deputy Mayor and the Commissioner when it first arose.
You mean our case study we're getting onto?
Yes,
But
yes.
the general looking to make sure that that area of the Met is fit for purpose, it's not something...
I've got no knowledge of
No.
us looking at it generally.
Thank you.
Yeah, thank you. Just following on Caroline's point, we had a memorandum from Sophie with 6 questions answered on behalf of the Met. Did you interrogate the answers you were given?
Which paper are you looking at?
This is Appendix A to the letter that Sophie sent the Chair on the 21st of December. And it talks about robust and proactive approach and every allegation being investigated and so on and so forth, about a robust and proactive approach and so on. Did you interrogate the answers you were given, or were you just taking them at face value?
Okay.
Can you point out? I'm sorry, I'm
Yes.
being deliberate.
A
I'm
letter
trying to be
from
deliberately
Sophie
obtuse.
Linden,
Yes,
21st of December,
yes,
Appendix A.
yes, Appendix A, yes, we've got that,
Right.
yes.
Okay, this is the memorandum from the Met to MOPAC,
Yes,
which answers, well, some important questions, yes?
yes,
Right. And they've given their account of what they do, like a robust and proactive approach to electoral fraud and so on.
yes,
Every allegation referred to the SET, a robust and proactive approach, and so on.
yes.
Did you take those answers at face value, or did you interrogate them after you received them?
Well, I didn't deal with this particular item of correspondence at the time. Since I was asked to attend this meeting, which was about last Friday, I've made certain inquiries and had a number of conversations with people, both within the police service and within the Crown Prosecution Service, to explore the matter and actually test
Right.
the validity of what I've been told.
Okay, but until you were appearing here, did anybody at MOPAC interrogate these answers from the Met?
I would assume yes.
You would assume yes, but you don't know.
I don't know, because I wasn't involved in it at that time.
Right,
no.
okay. Well, perhaps in due course you could send us a memo about what exactly was done to interrogate these answers when you can investigate that when you're back upstairs, yeah?
Yes, happy to.
Thanks. Can I go on to the questions I really wanted to go on to, which is training, first of all, and I'd like to ask Commander Secundi. We talked about the well-trained small team and all that. What training do your specialist officers have in electoral law?
As was alluded to earlier, in terms of ongoing development and training, so working closely with the Electoral Commission and APP, which is the professional guidance for all police officers operating in this area. So our officers are part of that twice yearly. There's the conference that occurs annually. When officers go to the team, there will be the bespoke training within that team. So we haven't, and Gail may be able to assist, certainly since my tenure in this post, had specialist electoral lawyers deliver specific training to that team. But there is, some of it is experiential development, as well as, as we do when police officers and, as a detective myself, when you go into new roles, part of your own continual professional development is to develop yourself into whatever the role that you're going into.
Yeah, well, that's not really answering my question, is it? I mean, let's start by amount of time. How much time in a year will an officer spend on training on this?
I don't know the answer to that myself. I don't know if Gail's able to assist me with that one.
The Electoral Commission send out weekly circulars which we have access to, so it's the information from the Electoral Commission, but it is very much personal development. And then there is the yearly conference, and twice a year there's the Integrity Roundtable.
So the yearly conference.
So it's a yearly conference.
And how long does that last?
It's a full day. Well, it's 2/3 of a day, and then it's followed by a round table.
Right, okay. And what level of knowledge would you expect your officers to have of electoral law? Would it be the same, for example, as a party election agent?
I think the roles of a party election agent and an investigator can be quite different.
They are different,
So-
but there's obviously it's a very different role. But you, as an election agent, I mean, I've done a course myself many years ago, which took several months in a correspondence course and attendance and so forth, to learn the basics of electoral law when I was qualifying to be a Labour Party agent. So I had to know electoral law to a reasonable level, not as much as necessarily as a returning officer who has to specialise in this field and as a local government lawyer, generally speaking, to start with. I wouldn't expect that level of knowledge, but the basics level of knowledge is what an election agent.
So as you
expect to know.
described the training development which you went through, there is no equivalent within the policing of that when it comes to electoral law.
So what level of knowledge would you expect an investigating officer to have?
So the level I would expect would be to have a good understanding. So as I explained earlier, they are not lawyers, which is why we work incredibly closely with the Crown Prosecution Service to offer us guidance and advice when it comes to the legal aspects of what can be quite a technical field. So the investigators do work very closely with the specialist lawyers in the Crown Prosecution Service.
You see, I mean, we've had this letter, I mean, I'm not going to go into detail, that's for later on, from Councillor Golds. And he gives various examples, and I would summarise it by saying, if what you tell us is true, the officers several of the officers doing this work didn't know their proverbial from their elbow about what electoral law was.
So if I may,
Very basic stuff.
yes, so if I may, that's the letter which was handed to me just when I walked in this morning.
Yeah, well, we only got it ourselves last night.
And as you say, from Councillor Gold, some of the examples as he describes them would lead to that conclusion. Now, I know that some of the examples are from some years ago. So the special inquiry team that we have now came in, that was created in 2013. The officers in that team now are not the same officers in relation to some of the cases that Councillor Olds has alluded to. But I do take your point.
Yeah, and then also in the MOPAC, in your response to MOPAC, so I think I could ask you this question rather than MOPAC. You're also saying here that the SET continue to deliver training and briefings to all borough commanders and their key staff, including bespoke presentations explaining electoral fraud and malpractice offences and the role of the police on duty at polling stations. What training do you, through the SET, give to the borough officers?
In terms of the detail of that, if I may refer to D.I. Granville to explain exactly what that looks like.
Yeah.
Well, as has been pointed out before, electoral offences are not part of a general police officers training, so they're not part of the syllabus when you join as a constable. They're not part of the syllabus if you're studying to be a sergeant and inspector.
I think that's reasonable.
So we're aware that
I think that's reasonable, but we would expect specialist people to know what they're doing.
Yes, and so because we are mindful of that, we know that an officer who's posted on duty at a polling station, that may be their first experience of elections, so they're given briefings which go through what the offences are, explain in very broad terms what the more obscure offences are, which they may never have heard of before, and also refer them to the APP, which does have very detailed guidance for what to do in the various situations, how to preserve evidence. We also, the Electoral Commission produce pocket-sized booklets which is issued to every officer who will be on duty at a polling station, again, which breaks down these are the offences to look for. Also consider your powers of public order and breach of the peace, which officers will be aware of. And it's just getting that message home, but also saying if there are any investigation, if any allegations are made to you, come to us, because we will then actually know what the potential offences are, because what we don't want are people trying to report something or turning up at the front counter of a police station and being told it's not a matter for the police, it's a matter for the Electoral Commission or for the council.
So when it says SET continues to deliver training and briefings to all borough commanders, is that face-to-face training?
It's at Tower Hamlets we do it face-to-face. We've done PowerPoints.
I'm not talking about Tower Hamlets, I'm talking about London as a whole.
Yes, so PowerPoints are produced because there are 32 boroughs, so the PowerPoints are produced, they go out to each borough.
So one of your specialist officers will go out to each borough to engage with the borough commander and stuff?
The PowerPoint, which is very self-explanatory, goes out to each borough to be delivered. We will go to boroughs where we're asked to attend, so Tower Hamlets is one where we will always attend. We've also gone to, I think it was Hillingdon. If we're asked to attend, we will go. We will make ourselves available to go. Each borough, so the 32 commanders, I have delivered in person to all 32 borough commanders when they come together for a crime fighters meeting to go through it with them. So
that's a collective thing when they all come together?
I've done that. So that you said about the 32 borough commanders, I have personally delivered training to the 32 borough commanders.
And for everybody else, it's the PowerPoint? The
PowerPoint goes out to the boroughs, and on each borough, an inspector is in charge of the running of that election, and they will then in turn deliver it
and is it checked that that's actually done?
Yes, it is.
Okay. Can I go on now to talk about the gathering of evidence, sufficient evidence? Can you explain, probably D.I. Granville, I suppose, rather than Commander Cundy, what the difficulties you have in gathering sufficient evidence to create a case to submit to the CPS, and what advice and assistance you get from the CPS in relation to this? I'll come to Mr. Thomas to comment after you.
Firstly, one of the major difficulties, and this is not exclusive to London, this is across the country, and it was borne out at the conference on Friday, is with electoral allegations. A lot of them are made counter-allegations by different political parties, and it's almost a tactic in the run-up to elections. One party or one candidate or agent will make allegations against another. So a lot of the time when we then make contact and try and follow up what has been alleged, they're either very busy in the run-up to the election period, and I believe Mr Gould in the letter I've had a brief glance of today give some such scenario where he's being asked to give evidence, and it couldn't be a worse time for him in his own campaign. So in some cases the difficulty is actually the person who's made the allegation is not able to speak to us and substantiate it, and then of course when you get the election result they've either succeeded and they're no longer interested in pursuing what they've alleged, or they've lost and they walk away and they're not going to pursue it. So that's one difficulty. The second difficulty is a misunderstanding between the difference of what is a breach of the code of conduct and what is actually a criminal offence. So people may see candidates or agents behaving in a way that they feel is criminal, but actually it's a breach of the code of conduct rather than something that we can prosecute. The third thing is, I think Mr Vamos alluded to it as well, that electoral fraud is a bit of a misnomer. Sometimes it's a breach of regulations rather than an actual dishonest fraud. And it's the proportionality about if somebody has breached slightly what they should put on a leaflet, on an imprint or what have you, is it proportional to actually prosecute somebody for that, when technically they may have committed an offence, but it wouldn't actually be proportionate to prosecute them for that. So they may end up with words of advice or a letter, and that may be seen by other political parties or members of the public that haven't followed it through.
Well, I think there's a difference of scale between getting your imprint wrong and some of the things that we will be talking about later on, isn't there? So
and if I could just one more thing,
yeah.
Just in relation to the recent EU referendum, because it was a referendum campaign and it was very emotive on both sides, a lot of people reported the matter to the Special Inquiry Team because they felt it was an electoral matter. And it was actually a hate crime, so in our figures it will say that we've got whatever it is, so many allegations, so we recorded them as referrals to us, but actually they weren't actually electoral offences, so we made sure that they went to the correct parts of the organisation that should investigate them.
If I may just add a couple
Can I come back to my original question then? I mean, you've told us how complicated it can all be with tit-for-tat allegations and all that sort of thing. But I come back to my original question. What's the difficulty in gathering evidence to put to the CPS when you get a credible allegation?
So if I may do part of an answer to that. So some of the real challenges for some of the offences that will be investigated, the very nature of elections, the secrecy of the ballot, unlike other criminal investigations into other matters where we will often have that hard evidence which we can recover, for example, CCTV, which we will not have in polling stations but we might have nearby, the challenges with postal voting where a lot of the evidence is not publicly accessible. So we have those seizing evidential challenges. But one of the other things which we do encounter, and again it is not unique to electoral fraud and malpractice, but I think can be exacerbated within this area, is when it comes to witnesses willing to assist in criminal prosecutions. So what we will often find is that witnesses, members of the public that have seen something or have an allegation to make, may be willing to speak to whether it's political parties or others, but when it comes from a police perspective, to request them to make an evidential statement that we can then use to present to the Crown Prosecution Service, many witnesses, and I say it's not unique to electoral fraud, are often unwilling to do that. And unless we have that evidence when it comes to a charging decision with the CPS, we just can't get to that point. But the other aspect of your question was about files to the CPS. So as I mentioned earlier, these matters are not like many other criminal cases where the first point we will often go to the CPS on a shoplifting will be at the decision point for a charge. When it comes to electoral fraud and malpractice, the first point we go to the CPS will be very much at the start of the investigation, which is we've got these allegations, this is what we've already identified, what advice can you give us in terms of progressing that investigation, what's the evidential requirements that we will need to prove, and that's what the specialist lawyers can give us. So it's not a file for a charging decision, it's an ongoing dialogue and engagement, but there will often be, on some cases, and it is few, a subsequent full file that would go for a charging decision on a particular offence or allegation.
Yeah, well, thank you for that answer. But equally on the other side of the coin, that in elections there is often a paper trail that doesn't exist for other offences. So, for example, if you're looking at postal voting, you have the certificate that people of identification, you have the electoral register, you have the marked register, and in particular the marked postal vote register, which seems to have passed some of your officers by according to the Tower Hamlets letter we had, but we may explore that later on. You can put all those things together and start to see what it is. And of course, there are circumstances in which you can go behind the secrecy of the ballot, although that's I accept, very limited. Talking about witnesses, though, we've heard in all the paperwork that hearsay is an issue, but isn't it your job to try and turn hearsay into admissible evidence? Certainly when I was in practice as a litigator, I'd often get stuff referred to me and say, so-and-so said so-and-so, I saw so-and-so said this or so-and-so. Well, it'd be my job to go and speak to so-and-so and find out exactly what happened. Absolutely.
And that's exactly what we do. That's the core part of the investigation. So, again, not unique to electoral fraud and malpractice. That is what investigators should be doing on all matters, is when we hear of something through a person, is to try and get back to the source of that information and try and secure it as evidence.
Exactly. Well, we may go into that in a little more detail when we look at the Tower Hamlets case, because that doesn't seem to have happened. And Mr. Van Moss, anything you'd like to add to what advice you give?
Yes, well, thank you. I mean, it really goes back to what Commander Cundy said at the outset. We work very closely with the police, not just the Metropolitan Police, but across England and Wales. I have two teams, one in London, one in York, with specialist prosecutors who advise from a very early stage, exactly as Commander Cundy has outlined. The difficulties that we see really are the same, again, as Commander Cundy has outlined. Identifying the suspect is often an issue. If somebody prints a load of anonymous flyers, you'll never really get to the bottom of who did that. If somebody registers a mass of false registrations online, the IP address may resolve to an internet cafe. You probably won't be able to get any further than that. Apathy, as Commander Cundy's pointed out, is a problem in local elections, certainly where turnout is historically lower than a general election. Even if somebody is told that somebody's voted in their name, they may say, well, I don't care because I wasn't going to vote anyway, and I don't really mind who the councillor is, and so they won't even give a statement. So that's something that we come across. A distinction I would make, though, which I think is important, is the difference between gathering evidence and proving the offence. Not the same thing. So there are some cases, and as you've outlined in postal voting, there's a mass of evidence. But it doesn't mean that that will enable you to prove the offence. We still have to apply the Code for Crown Prosecutors. We still have to be satisfied that there's sufficient evidence for a realistic prospect of conviction. In other words, that we could prove to a court or a jury beyond reasonable doubt that the suspect has committed the offence. So even when you have all of the evidence, you still may not be able to prove it.
I can answer this question as a lawyer, hopefully. Do you also look at the possibility of inchoate offences?
Of what, sorry?
Inchoate crimes around these, conspiracy, attempts, incitement and so forth?
Well, you can do. The difficulty there is sometimes they're just more difficult to prove. For a conspiracy, you have to prove an agreement. You can have circumstantial cases where an agreement can be inferred from the evidence.
Sometimes that might be easier than trying to prove some of the other detail.
It's very difficult to talk hypothetically. In my experience, inchoate offences are often more difficult than substantive offences.
Well, we may come to that later on.
Of course.
And I think I finished, Chair. I learned to say to Mr. Matt, I look forward to seeing your memorandum on what efforts the MOPAC made to interrogate the memorandum from the MPS, and if there were efforts, I'm rather surprised we didn't hear about it before, if it was to in some way correct or add to Sophie's letter of the 21st of December.
Evidence it's most useful to have a lawyer on the committee. Tony.
A couple of questions of Commander Cundy, please, relating to the collection of evidence. You talked to us about the difficulties of finding evidence for electoral offences, and you vaguely outlined some of the other work that your department does. Can I initially ask whether or not you were involved in Operation Midland? Was that part of your responsibility?
So, no, I wasn't involved in Operation
And it
Midlands.
wasn't part of the... Your department was not involved in that at all?
Not, the Special Inquiry Team is not involved in Operation Midlands.
Right,
No.
well, thank you for that. You've told us that your team is made up of experts, people who have been involved in this, and yet you have told us that you submit at a very early stage evidence you have to the CPS to see whether or not they can form an opinion. If your staff are experts, aren't they able to sift that out?
Well, as I explained, they are not. So, police investigators are not lawyers; they are investigators.
Yes.
They will have an understanding and a knowledge of the law which will be greater than other police officers in other roles. But the reason we go to the CPS is because of that legal expertise, and that's why we'll seek their advice within this aspect. So the the specialist lawyers in the CPS, because and I think as I explained, there are two for England and Wales that have this expertise.
I understand those points. When you talk about your staff having experience, how many of them have served in your department, shall we say, for longer than 5 years and have experience of electoral matters for 5 years or more?
You'll have to forgive me, I don't know the answer to that, Percy. I don't know if...
Well, you have a very tiny staff, you've just told us.
Yes, I have a very small staff within the Special Inquiry Team. I also have a very, very broad portfolio.
Yes.
I think all of the staff have been detectives for more than 5 years, but the Special Inquiry Team only took over responsibility for elections in 2013.
So there is not a body of experience within this team relating to electoral matters.
Well, you could argue that since 2013 we've actually had the 2014 elections, the general election in 2015, the London mayoral and the EU referendum in 2016.
I think most of these complaints relate to a period when your specialist staff will have come to it completely fresh, won't they?
2014 was their first
Yes,
opportunity
right.
as the spot for the Met.
You see, I'm a bit foxed about this, Mr. Chairman, and can I say initially how disturbed I am to hear that Mr. Merritt only knew about these matters on Friday. I think I would like you to ask Mr. Merritt if he can explain why this has happened in this way. It's not going to be possible for us really to ask Mr. Merritt about this when he tells us that he's barely had a weekend to look at these matters. And similarly, Mr. Cundy, as far as elections, you haven't been involved in this for a sort of a terribly long time, and therefore not able to evaluate, I think, forgive me for putting it bluntly, electoral offences. Many of the offences which have been listed are not, and I think that Mr. Vamos has suggested some of these things are very hard to prove, but many of the accusations, which I'm sure will come along later, loads and loads of witnesses, which I understand, if proper witness statements are taken, counts as hard evidence and not hearsay. But we'll come on to that later. But could you explore with Mr. Merritt now why he only knew about this on Friday?
I agree. I mean, this is all of a piece around my... Let me just preempt. This is all part of my introductory comment showing our disappointment, the fact that, frankly, MOPAC had to be dragged here kicking and screaming, despite the fact that we have a letter from the Deputy Mayor effusive about how important this is and how robust MOPAC is. And, and this, again, is not your fault personally, Robin, but it is evidence of MOPAC's disinterest in this subject. Would you like to respond to that at all?
Well, I don't think there's evidence of MOPAC's disinterest in the subject at all, and I stand by all the lines that the Deputy Mayor has written to you. The fact is, and it might not have exactly been last Friday, but certainly within about the last week or 10 days, I was asked to appear here. I hadn't previously had engagement with this particular matter because there are lots of other people who work, on such matters within MOPAC. We have a few people who deal with those areas. The person who was dealing with it and had been dealing with it is away at the moment and not able to attend the meeting, and I was asked to attend. Since being asked to attend, I've gone through the papers, I've made my own inquiries, and I should be able to answer the questions you pose.
There's nothing in your papers about the point I asked you about.
Well, there was nothing about specifically saying the level of inquiries were made by an officer when they received a note from the Metro Police. No, there's nothing
So
like
there's
that.
no email asking questions about it, or are you absolutely certain about this, or anything like that?
No, but I probably wouldn't expect that to be either, to be honest.
I mean, this is the, again, Rob, this is the second time I believe that you've had to step in on my committee at short notice because someone else hasn't been around, which is more of a structural issue with MOPAC than yourself. And we appreciate you being here today.
But I do find it surprising, Chair, that you wouldn't expect there to be copies of any memoranda or emails or something sent to the Met asking questions. I mean, certainly when I was in practice, I mean, it's maybe slightly different in MOPAC compared to the solicitor's office, but everything's recorded. And particularly on something like that, if you were saying that MOPAC's process is not to record inquiries of the Met following up on memoranda you receive from them, I think that's a very worrying position.
I think we have picked up on this, on our actions post this meeting. I think we got some serious questions to ask MOPAC around that particular process point. Right, moving the debate on, I think we want to talk about an overview of most recent national data. Caroline, you're leading on.
Yes, I'd like to ask Claire from the Electoral Commission whether you can set out for us broadly the types and volumes of accusations over the past, say, 3 years in London and the UK. I think you put out a report in March 2016 which showed quite a few cases, 481 cases of alleged electoral fraud and so on, and yet at that time only 4 cases had gone to court proceedings.
So what would it be helpful for me to, I mean, essentially what we do is we record the cases and then follow those through the different stages to which to get there, which you've alluded to and you've got there. I don't have any more information than you've got there in front of you here. And I don't, I'm afraid, have with me a breakdown by case type for London within that, I'm afraid. So I can't do that now. I'd be very happy to send that through once we get back from the office. And I think there are some figures that the Met have around the allegations.
Okay, but what are broadly the types then of accusations that you have picked up from gathering this data?
So I think the best way to describe it is to divide it in the sort of voting process. So by far the biggest type is campaigning type offences. So that will be offences around the candidate registration forms, quite often around the signatures and the attestations on that form, incorrect signatures or wrongly put on there. And that's a very big chunk of the allegations and the frauds and behaviour around campaigning and activity around that. And then the second area is around voting offences themselves, so that would be behaviour around the actual act of voting, like personation or fraud around postal votes.
In terms of your work, though, there seem to have been prosecutions for electoral fraud in other parts of England over recent years, but not, it appears, in London. How do you explain that? Is that something you've looked at?
We haven't. I think if you're asking whether I think there should have been more in London, I think it's not the role of the Commission to look at investigations and make judgment calls about those investigations. There's other organisations, regulatory bodies that carry out that function. What we have focused on is raising awareness of this matter, of this broader issue of encouraging better communications and encouraging wider communication about things like how to report offences. But we don't have oversight of actually how investigations are conducted, and we don't have the expertise to do that, and that wouldn't be part of our role.
Could I just say that we actually did have a conviction from the 2014 election for a candidate nomination offence, which was a candidate in Enfield.
Enfield, did you? So from 2014 local elections.
He was convicted in 2015, but it's from the 2014 election.
Okay. I think that's probably as far as I can go on that section, isn't it?
Just a quick question, probably to Commander Cundy. I've been asking questions about Appendix A in the letter that Sophie Linden sent us on the 21st of December. But there's no author to Appendix A indicated. Do you know who wrote Appendix A?
So that so my name was attached to that. That ultimately came through me.
So you
through
signed
to the deputy.
So you authorised it and signed it off.
Yes, I did. Yes.
Okay, Can answer your question. Right. Caroline, you finished your line of questions?
I think so. I think we'll get something in writing by the sound of it from Claire afterwards with the details. So.
Chair, if it may assist, particularly to London, so in terms of 2014, if I could just, the top 3 offences which we received referred to us so this is particular to Tower Hamlets. If I may, then I can do some comments about the general election of 2015.
Right, this is we were doing generally, aren't we, at the moment?
Yeah, we are doing generally.
So if I may, on the general election for 2015, so the top 3 offences, so there were 8 allegations made to us in relation to section 110, which is around imprints. Mm-hmm. There were 6 in relation to section 65(1), which is tampering in relation to postal ballots. Mm-hmm. And there were 5 allegations each, 1 for false statements on nomination papers, and 5 personation, which is section 60.
Mm-hmm. Okay. And would that generally fit with audits across the country? That's generally how it breaks down?
That profile of the different types of offence.
Okay.
Chair, if I may, on the question of whether there's a distinction between the success rate in London and the rest of the country, certainly from CPS's perspective, there isn't. We see allegations from all over the country. We apply the same test to all those allegations. We don't see any difference in the quality of the file, the quality of the evidence. In fact, the Met have a specialist team which distinguishes them from many other police forces.
Should do better then.
Yeah. Just following from what you said, Nick, I mean, you use the term success rate in London, I would say the failure rate in London. It's the other way around.
Well,
but
yes,
surely,
same difference.
The letter from Councillor Goals actually talks about prosecutions in different parts of the country, in Derby, in Woking, in Slough.
I haven't seen the letter, I'm afraid.
Oh, sorry, you haven't seen the letter.
So
but you are aware that there have been successful prosecutions?
Yes, because my team prosecuted.
Elsewhere. And so why the case? What's gone wrong in London?
Well,
I mean, you talk about, it's the same test, obviously, nationally.
Yeah, I don't accept the premise of the question.
I put it to you,
Mr.
it's a
Desai.
failure to apply the evidential test in a proper manner, failure to collect evidence and so on.
Each case has to be assessed on its own facts, and where the evidential test is passed and it's in the public interest to prosecute, we will do that. Where it isn't, we won't. So I don't accept the premise that there's some problem in London. We assess each case individually.
We will be obviously investigated in the second part of the meeting. I know Andrew will come to you, but Tony, on this particular point...
On this particular point, you, Mr Van Moss, have referred to the fact that the MPS has its own department which looks into this. Do you not think that that in itself perhaps contributes, if you like, to the cases which you actually have referred to you, which lead to a successful prosecution? In other words, could it be that by virtue of the fact that the police have their own department which looks into this, that they in effect filter before matters are referred to you, whereas that doesn't happen in other parts of the country?
I would have to look at lots of individual cases to form an informed assessment. But my impression is that's not correct, because it goes back to what Commander Cundy said at the outset. We get involved with these investigations very close to the point that the allegation is made, and we advise the police throughout.
Mr. Job, if I may, yeah. So I had the equivalent responsibility for 2 other police forces outside the Met before I took over this role, and whilst there isn't a specialist team that simply is there to deal with these types of allegations, you still have a group of officers within might be part of a broader team who are the ones that have the additional specialist knowledge, and the process which those 2 forces adopted is very much the same as the Metropolitan Police has.
Can I ask whether or not those other forces which you deal with are forces which have led to successful prosecutions? Do you do Berkshire, for example?
So whilst I only read the letter this morning, so one of those forces was Surrey Police. There's the Woking matter. I don't know the full details of all the other cases. I'm aware of the Derbyshire case, when in that circumstance the individual admitted the offence. I don't know about the other matters.
All right. Okay, thank you, Chairman.
I mean, the letter we only received last night anyway, so I do apologise, but we thought we'd table it so that you at least had it in front of you. No, I get that. Andrew,
just a quick one to Commander Cundy. Presumably, if MOPAC had interrogated your Appendix A, it would have come to you?
It would come through to me, yes.
Did you get any inquiries from MOPAC about it?
Yes, I did, yes.
Okay, and have you got a record of those?
So there will be an email trail between MOPAC and the MPS, and certainly I spoke to someone from within the Deputy Mayor's office on the phone myself.
There is an email trail.
There will be some emails.
There will be an email
the
trail.
content of those, Mr Dismore, I wouldn't be aware of.
Thank you. Well, perhaps either you or Mr Merritt can produce those emails in due course.
Okay. Right, the next set of questions, Peter, I think you're leading on, is around community vulnerability.
Good morning. This is for Claire Bassett. Good morning. As I understand it, in 2015 you commissioned some work from various universities as to why some Bangladeshi and Pakistani communities might be particularly prone to electoral fraud. Can you tell us something about this, please, in a little bit more detail?
Yes, certainly. So that research looked at what the vulnerabilities might be, and it identified a range of vulnerabilities. It identified within that some of the things which are strengths of those communities, the kinship networks and links which could also create vulnerabilities for influence over how votes were cast. It also looked at what we could do to improve communication and education around some of those things to try and prevent that happening.
So could you tell us a little bit more, I mean, just maybe give us some details. When you talk about kinship ties, you mentioned in the report that there were sort of patriarchal hierarchies, etc. I mean, how did these influence voting behaviour?
So I think essentially what that did was looked at how, particularly in the absence of some other political parties where there was a limited amount of options for who people could vote for, that was those kinship networks had actually led to influence being placed on people to use their vote in a certain way in order to support that network and the person that network was supporting.
But can you sort of tell us, how does it actually work? I mean, how does the pressure come to bear? How does it actually work, as it were, in practice on the ground?
So I think the first thing to say is I am not an academic expert on this matter, and one of the reasons the Commission commissioned experts to do this was in order to use their expertise. So I'm very happy to share my understanding of it, but I just want to caveat that with I'm not an expert.
No, but presumably they must have researched and reported on it.
Yes, so I think that influence is around the networks and particularly extended family networks and links within those. I mean, I don't have specifics here, I'm afraid, and it's not something I can go into enormous detail on, I'm afraid.
But I think, in a way, it's sort of nub of the issue, isn't it, in a way? I mean, particularly I was thinking in terms of, which you don't mention, I don't think, or I haven't seen any mention of it, how this might affect the position of women and how they vote, particularly. If you're talking about patriarchal ties, how does that play out? These people did the research for you, so presumably they came up with some examples of how that works exactly.
So I think for women that is about influence within the home, and again issues such as language barriers and poor understanding of public information and or ability to read ballot papers and guidance around applying for postal votes and that sort of thing made them vulnerable to that level of influence.
So they're told how to vote by the males in the household or whatever.
I think there was an identified area where that was some of the vulnerability. Yes.
Right. Okay. So, I mean, did you, having seen this research that you commissioned, what conclusions did you come to about how this could be best tackled?
So I think the first area was around our public awareness, and I think that needed to do two things. I think it needed to get across much more clearly what appropriate campaigning is and what inappropriate campaigning is. And, you know, if you take your question you asked earlier about what was happening, so what is unacceptable needs to be much clearer in our communications and our public awareness activity so that voters know what they can and can't expect in that circumstance. The second area of public awareness was around actually how to report fraud or risk if that's becoming apparent and making that clearer, and then also within that looking at addressing how we can do that in areas where there's very low levels of literacy or where English can't be read or isn't the English language skills aren't at a level which will be able to understand that. And then also, you know, the code of conduct for campaigners sits alongside this about being very clear with campaigners what's acceptable and what isn't.
So when it comes to codes of conduct in campaigning, who should it be made clear to, as it were?
I think this is one of the challenges. It's one of the challenges certainly that Sir Eric picked up in his report, that the code of conduct needs to apply widely to all campaigners, and it needs to be something that perhaps has a more statutory footing than it has now. It's voluntary at the moment, and that's something that we've been seeking to change. I think that the definition of campaigner is difficult. You know, it's very obvious when you've got an immediate politician and perhaps the immediate people linked to that politician, but then when you get into broader networks, and again, from our point of view, it's about making sure that code of conduct goes as far as possible and that parties take responsibility for that code of conduct going right out to the front line of their campaigns.
I see. I mean, I have to say, it might have been quite useful maybe to have had people from the universities who've done this research here as a witness, because I think people need to know actually what we are talking about. We're talking about football. How does it actually physically work? Are people marched into the booths? Obviously, we know there are not security cameras. How does it work? What are we talking? Because surely we have to know those details before we can actually tackle or make your job.
And I wasn't asked that. I mean, unfortunately, they're not today.
Part of that, we may be able to scrutinise some of those parts in the second part this morning, potentially, because I think some guests may wish to be. Unless you want to come in.
Just carrying on from where Peter left off. A question to you, Claire. Would you agree with me that codes of conduct, protocols only work if all parties sign up to it genuinely?
Absolutely, yes. And we would like to see them on a compulsory footing.
And clearly, and we'll come to this in the second part of the morning, where one or two parties clearly don't have any regard for codes of conduct, protocols, any respect. It's really law enforcement that is...
It makes it very difficult, and it's one of the
things... That's what we should be talking about.
Yeah, and it's one of the things returning officers find the most hard and makes their life very difficult if you have some particular campaigners or parties who refuse to abide by that code of conduct when they're campaigning. That also adds to things like the tit-for-tat type allegations and that whole atmosphere growing, which again makes it very hard to do this.
I mean, self-regulation depends on the integrity and discipline of the parties.
Yeah.
Right, the last set of questions before we move on is, and you referred, Claire, to Sir Eric Pickle's report recommendation.
There was one question there left. So that's
I'm sorry, Peter. I don't want to shortchange you. Peter.
To Commander Cundy, I mean, what particular difficulties do you have in collecting evidence from the communities that we're talking about?
I mean, there are a huge number of very distinct communities across London.
Yep.
And again, some of these issues are not unique when it comes to electoral fraud and malpractice. So some communities will have a significant distrust of the police, as you as members will know, which is why from the Metropolitan Police we are constantly seeking to improve our local engagement with communities to secure that confidence, whether it is in relation to coming forward around electoral fraud and malpractice, or indeed in relation to other crimes, antisocial behaviour, etc. So it is challenging. Some of that can be legacy reasons within that community in London. Some of it can be the challenges for individuals who may have come into London in recent years and have that inherent distrust of authority, in particular the police, and where they may have come from. So that is always a challenge. You know, the ways to overcome that are that long-term engagement and the work we are doing from the Metropolitan Police and under the Deputy Mayor and the Mayor to improve that local connectivity within our local communities is going to be very, very central to that. So I think the challenges, as we picked up through the report from the Electoral Commission, they are the ones which we face. The trick from us as the police, and indeed us, but with all our other partners in this area, is to try and find the way to overcome them.
So you haven't sort of really made any headway, really?
Well, no, I think we are continually making headway, and I think that is often down to individuals, and particularly our borough commanders and the leadership which they give within the boroughs across London is very key in terms of that engagement through community members, key critical friends and critical stakeholders across all of our communities in London.
Is there a problem, just one more question, what I mean, you're talking about challenges and the problems, and I think we all accept that there are obviously challenges and problems. It's just a question of how you're doing it and what you're doing. Isn't there a problem too? You can tell me if I'm wrong, but that you might be a little concerned as police now that you don't want to be culturally insensitive to people and their particular attitude to and their values towards the electoral system, so that might actually inhibit you?
I don't think I agree with that statement in terms of it inhibiting us, no.
You don't?
I think we will always be sensitive to different cultures, but our role is to remain neutral and to follow the evidence within this. So yes, we will always be sensitive, as we will in all aspects of policing, but no, I don't agree with the statement that it is inhibiting us, no.
I see. So if a woman, just in case, I mean, it probably hasn't happened, if a woman from Pakistani or Bangladeshi community came to you or something and said, I think that my husband's forcing me to, you know, or whatever, or is possibly intimidating me to vote a certain way, you wouldn't sort of send her away and say, well, you know, we respect your culture or anything?
I would not expect any of our officers to send them away, no.
Thank you very much.
No, can I just add to that? You know, certainly there would be no, you know, MOPAC would totally support what Stuart Cundy's just said around that. There would be no expectation that people would be sent away. The whole Mayor's drive round increasing the diversity of the Metropolitan Police Service, the drive towards neighbourhood policing, is all about, you know, better engagement with local communities, local individuals, so those barriers are broken down.
Okay, all right. Last set of questions. Sean, you're going to lead on about the Pickles report recommendations.
So the Pickles report, the government response to that responded quite positively to most of the 50 recommendations. Can I ask Claire possibly to outline the main changes that are being put forward as a result of that?
Certainly. So if I start with the ones that got the most attention, the first one was around ID in polling stations. They announced that they're going to be running a series of pilots at the 2018 local elections. They do mention the higher risk areas in that, but I don't think it's assumed that pilots will definitely be in those areas. But those pilots will look at the use of ID and varying forms from photo through to the utility bill type ID, and we will be involved in that, in evaluating them. The other sort of main area was around postal votes and looking at measures to prevent what's colloquially known as postal vote harvesting and preventing campaigners from collecting up large numbers of postal votes and taking them into polling stations. There was also a recommendation to look at the taking away just postal votes being enduring and instead having a renewal period for those and that side of it. There are then a series of recommendations for changes to our guidance, most of which have already been done, which are around about practice in polling stations or around polling stations. So the use of the cordon sanitaires, the tightening up some of the guidance around activities in polling stations, making sure that people are not accompanied into the booth, that sort of thing. And although that was in the guidance, there's about 8 or 9 areas where that's been tightened up as a result of that. And then there's one more area, I can't think what it is, but I mean, around electoral fences and having a look at that. And I think that goes back to the earlier conversations we were having about just how difficult the law is in this area. The law commissions have also done a piece of work looking at how all of the law could be simplified. A key part of that is the offences around electoral offences, and although the government is not anticipating being able to get a single bill that will respond to all of the Law Commission's recommendations, it is committing to taking parts of that forward, and electoral offences are one of those.
Okay, can I ask just you, first of all, do the recommendations and the actions taken, do they reflect well the levels of offences of different types? Because I think earlier on you outlined most things were to do with registration problems, fraud on the forms. The things that might lead to prosecution seem to be mainly offences committed by campaigners rather than relating to the actual voting and the postal ballots. Is the balance right in the changes?
That's a good point. I mean, I think the changes to the nature of the offences, and CPS might have it, at the moment the offences are are very old offences and don't feel hugely relevant to modern life. And I think that actually changing some of those offences to make sort of undue influence clearer, I think will pick up those areas. I think, you know, we talked about sort of the registration type offences. I mean, they are quite clear at the moment. They're there. That is a failure to follow the rules about that. There are some really small areas we would like to see in just better clarity around the law of those, but I don't think they need quite the same attention as some of those other areas. I think the thing that affects all of this is about confidence in elections, and I think that the perceived risk of fraud and the research we've done, which shows that actually ID in polling station is the thing that people most often quote as something that would give them more confidence in voting, is one of the things that's led to that attracting perhaps more attention than others, I think.
Okay. In terms of activities around polling stations, I've been, and declare an interest, I've been a candidate, I've been an election agent as well, and I've taken part in campaigns around London in lots of different boroughs. The actual enforcement of the things like the cordon sanitaire seems to vary quite widely around different boroughs. Is there a sense that you'll be making the rules, the enforcement more consistent and
yeah,
so more consistent police practice there as well?
Yeah, so one of the things that we have clarified the guidance on is that, and made that clearer, so ROs are very clear about what they can and can't do in specifying that. It does vary because in some areas you just don't need it or it's not feasible compared to other ones, and I think one of the things we work very hard to do is to encourage the best practice, particularly RO relationship with local police on polling day, so you've got the police presence to enforce those cordon sanitaires and to do that, and that's something again that particularly in the run-up to the next elections we are working on with local authorities and with the police.
Can I ask the police representatives now, are you in support of the changes proposed? Will it have an effect on the workload? Maybe not for the special inquiry team, but maybe on election day, if there are queries about ID, people wanting to challenge the fact they've been refused to vote. Those kinds of issues might lead to a higher workload.
Yeah. Whether it lead to a high workload, I'm not sure. I think that Met Police and and National Police Chiefs Council, we welcome the report from Sir Eric. There has been said, there are some aspects of the law which I think could be brought up to date, which would assist investigators and would insist some of the decisions that we then have to make. And one of them that stands out for me is around residency. It is shown in terms of the definition of what residency means, we have found from an investigative perspective. But in terms of on the day around polling stations, I speak from a personal perspective. I would be supportive of there's going to be a number of pilot areas around identification, I understand, which I think is a step forward to identify what is the best approach to take. If there is clarity that comes out of this for officers that will be on duty at polling stations, then I think that is only going to be of benefit. And if officers are, if it is straightforward enough in terms of what the changes of the law may be, then that will be part of our briefings, our inputs to officers that are on duty. And if they don't know the answer themselves, that's why we have on election day, the special inquiry team are on duty. So if an officer doesn't know the answer, they know someone who will.
And do you think it'll affect outcomes? How allegations are tackled, how many are brought for prosecutions or warnings?
I don't think I could give an answer to that, but I think in terms of an outcome which is about the perception, which we've just heard, then yeah, I completely echo what's been said. I think if it gives the additional confidence and if it enables that, the free, fair elections, the free flowing of the day, then I think that can only be a positive outcome.
Andrew, do you want to come in?
Yes, a quick one for Claire, really. I mean, we were talking earlier on about training, and we understand from Diagramville that there's a set of slides that are sent around and so forth. Did you participate in the preparation of the slides?
I don't know the honest answer to that. We may well have done. We do, the specialist experts in my team do work very closely with the police and are very willing to have input. And I think, just to sort of come back to the Law Commission's recommendations, there are over 20 primary pieces of legislation in this field and 80-something bits of secondary. And in fact, there's a real risk, as I found out, that actually you think you've understood the specific rules around the number of days before something that has to be done, or what the residency rule means in here. But actually, because the different secondary legislation or primary legislation has come from different places, you can actually have very different sets of rules for 3 or 4 different sets of elections. So there's almost a danger of being, knowing enough to be dangerous, and it being such a complicated area that it's almost more important that people know where to go to get the expert advice around some of that when they need it.
Yeah. Well, perhaps Di Granville can send us the set of the slides in due course anyway. But I think you make an important point, which really is my main question. I wouldn't expect the police necessarily to know what the various deadlines are for submitting nomination papers and all that. That's not really a big issue here. But do you think that there's more you can do to help train the police in this area of the law?
So we do a fair amount at the moment. As we said, we have the newsletter. We run the single point of contact seminars annually and a biannual round table. And we do that very much with the police, so we make sure we build on experience of what the police have done, and they share their knowledge within that as well. When asked, we do support and feed into other training and other events like that, and we make sure that if there's a development or something was to change, then we make the police aware of that. I'm not sure what more we could do reasonably in the circumstance of it that actually also would reflect the sort of burden it would place on the police in some areas about keeping up to date in the breadth of it.
And the syllabus, for want of a better word, of these away days, for want of a better word, is that set by you, or is it set jointly with the police?
It's done jointly. The seminar is done jointly, and the round table is by us. So, and it very much is done, it's voluntary, and nearly every police force has at least 2 people there. So, we're very focused on making sure that we keep it meaningful and we keep it focused on areas. So, the one we had last week focused in particular around these issues of registration and the experience that they'd had recently in Derby, and also looked at some of the registration and experience in Pembrokeshire, where they had had a multiple registration identified of voters from a house, and the experience of that.
Perhaps you could send us a set of materials that you use.
Yes, certainly.
Thank you.
Yeah.
And last question from me, you'll be pleased to hear, at least for this section, for Mr Cundy and Mr Merritt, is: do you think that the Met or MOPAC need more powers? And if so, what?
If I go first for me, so I'm not sure it's more powers. I think there is, as we've just discussed, clarity in some areas. We talked about polling stations. So the short answer is no, I don't think it's about more powers. Definitely around clarity of roles, and I think it is that, as always, so it'd be very naive of me to sit here and say we get it right all the time. That it's fine. But it's always going to be a continuing improvement. So every election which occurs here in London, and indeed elsewhere, the real benefit, the work we do, the Electoral Commission and the work nationally, is that you learn from what other forces have experienced. Just refer to 2 cases there which were discussed at the conference last week, and for absolute reassurance for yourselves that those national conferences, the Metropolitan Police is always at them. From our
Yeah, I don't believe that we need any more powers in this area, and I don't think any of the reports that have looked into this matter, and obviously the ones we've spoken about, the Eric Pickles report or the Electoral Commission, have pointed that PCCs should get more power. I mean, police and crime commissions generically should have more power in this area.
I'm glad that both of you said that you don't really need more powers. It's actually, in my opinion, using the powers that you already have and exercising those powers. And let me give you an example. What we have in certain parts of East London, and I think from what I've heard, parts of the outside London as well. On election days, there's large groups of people hanging around outside polling stations with a view to explaining the process to the public going into vote. And you get police officers just hanging around, basically observing what goes on. And you can clearly see what I would say is voter intimidation or pressure on voters to basically change their minds or to vote in a certain way. And I'm talking of groups, in some cases as large as up to 50 people outside one polling station. It even happened in the last mayoral elections in May. I personally saw one polling station in East End with about 20 to 30 people just hanging around outside. and there was a police officer standing there. Now, surely, I mean, apart from common sense policing, there are various powers out of thought, such as obstructing the highway, or if not, they don't move when asked to do so. And it's really a question of why are those sort of powers, being used?
So I think there's probably two parts to my response for that, if I may. So you're absolutely right. There are powers which police officers have, which are beyond electoral matters, obstruction of the highway being one of the obvious ones there. Intimidation, which you referred to, is an interesting one for us legally. In fact, I think the Securing the Ballot report talks about defining intimidation. So from a police perspective, we are often used to it when it comes to witness intimidation, those sort of aspects. And I think it comes down to the input which officers will need to have within polling stations. So our role on election day, the election day is not about an investigation or making securing evidence. It is about elections. And so our primary purpose is that free and fair election, the smooth running of the day. If there are powers which we need to exert, that's why the training we give, and in some boroughs it's joint training with those who will be within the polling stations themselves. So there is officers feel empowered and assured in the steps that they will take. So they might not have direct expertise before that day around the issues around the elections and electoral fraud malpractice at polling stations, but all police officers have training and input around public order offences and breaches of the peace. And sometimes, and I can imagine there'll be a situation where there'll be a tension for a police officer where they might be looking at it through that public order lens as opposed to the electoral lens, which common sense, I can understand that, because that's the knowledge and the understanding that they will have. And that's why the police officers have discretion. The role of myself is to make sure that they are trained, aware of the differences and the benefits of going down one path or another.
Can I just add part of what Commander Candy said about building on the learning? So obviously after 2014, the message was about the conduct outside polling stations, and we recommend is the set that each officer who's on duty outside a polling station is asked to complete a duty statement at the end of the day where they are recording if there were any incidents. And we also recommend, and it was taken up in Tower Hamlets, that body-worn videos are worn, so if people are collecting as a group, that the officers can actually get the evidence then and there.
Can I just ask of you, Claire, would you actually look into this when you're sort of reviewing your guidance and procedures?
Yes, yeah. We can.
Another example, and this has happened again outside, both in London and outside London as well, but I'm not saying it happens that often, but people, and certainly people in the gallery who've seen this firsthand, actually going into polling stations with elector, again with a view to translating or helping them, what sort of help is provided is a matter for debate. Well,
and
I think we all know what sort of help is provided.
Yeah, that's one of the specific areas that has been made even clearer as a result of Sir Eric's report. And again, it's an area where we're very conscious that needs to be really reinforced with everybody in those polling stations to make sure they understand absolutely what the rules are and are very vigilant to that effect.
Chair, if I could just follow up on that particular issue. So that's, I get to understand that's the activity between what you're asking your police officers to do on the ground on election day. What about crimes during an election period that may be brought to your attention? Because the nature, and we can't help it and we're moving on to it in terms of Tower Hamlets, there seems to be a systematic type of abuse going on at different times and a level of activity, whether it's criminal or not, that may well be brought to your attention that might persuade CPS there's an atmosphere or a issue that's generating a level of activity that should be of concern to the police in terms, not just for electoral fraud, but in terms of criminality. So am I taking it that your advice to officers is for the election day and polling day duties, but what about that period? If I'm sitting in Tower Hamlets Police, if there is something that someone says in a complaint, and I think this is due to the election, would that automatically be referred to you, or would that stay on borough?
When the purger period starts across the Met, there is advice and guidance issued which is on the front of the computer for everybody logging on each day. So at the start of the election campaigning period, so that all officers have an awareness, and that very much says if you've got any concerns, you contact the Special Inquiry Team. And we do start to get allegations, which the picture that you're saying, they build up and they escalate as campaigns get closer to polling day. But we start investigating them as soon as we get them. We don't wait, and things don't just come in on polling day. So they start well in advance of that.
Okay. But there are some crimes that might not come to you then. So you might not be getting the full picture of some activities that might be of importance to you in terms of carrying out your investigations.
If it's an election offence and it's reported as such,
it will
come to my team.
Other associated
and
crimes.
Then if we're talking about intelligence that's to do with elections on the Met Crimint system, so the intelligence report system, there is a flag for officers to put if it's related to elections, and we will search on that daily to pick up anything else. So it's not actually an offence, but the officers thought this has got something to do with elections, and they've given it that category. So we'll pick up things from there.
Thank you for that. Can I go back to some of the questions I just wanted? I want to go back to a bit like decision making, and just to clarify something you said earlier on. You get the complaint, you investigate, you take, then there's a choice. The choice is either to involve CPS at that earlier level, or you carry on with your investigation and just deal with it at the appropriate point with CPS. Have I got that right in terms of the choices that you have of when does CPS become involved and when don't they? Yeah.
I think with the CPS, and I think Nick's alluded to this, we have we're working with them very closely, so they're involved very early on, and they will know how many allegations we have in broad terms for any election. From the beginning, and we'll say there are a couple of these that we bring to your attention now, and they may ask for more detail and documentation.
So your own internal decision making as an investigation goes on, and I get it, this is a complex issue in terms of election fraud or any type of fraud, but fraud in terms of where that is. So in terms of who signs off what at what stage, depending on the complexity of the investigation, are there any referrals back to the local borough command, because there may be issues of clarification? Who's doing what in these circumstances as you take a case and progress it? Who's signing off what?
If we take it at the very lowest level, so if I go back to imprints, so we may get an allegation that something doesn't have an imprint on it. We get a copy of the leaflet, we turn it over, there is an imprint on it, so clearly there's no offence. So with some allegations, an allegation is made and we can very clearly see from the beginning there's no offence. So that will be closed off by the investigating officer, and before a crime report can be closed, that has to go through their line manager. So where there is clearly no offence, and that's a very basic example, then that will be closed within the team. We wouldn't need to speak to CPS about that. We can use our own eyes and see there's no offence.
And that's all contained within your team? There's no other referral process? There's no other, I need to consult with someone else within the Met? This is a straightforward case, I'm dealing with that.
If it's no crime, and that would be no different to any other team.
And on the less straightforward cases then, what's the procedure for that?
And then
how does that work?
with the less straightforward case, then there is that investigative plan, the gathering of the evidence, and the considerations about CCTV witnesses, Commander Cundy's referred to, and those would be the ones that we would be speaking to the CPS to say this is the allegation, this is what we've got, this is what we intend to do, and they may give us some advice as to things they should follow up, and these are all documented on the crime reports.
And there's
we
a
can take it as
straightforward,
far as the evidence.
And there's a straightforward line, it's all between your unit, CPS, no other
when
people
we're talking
consulted.
if we're talking in very general terms. So if an allegation,
we're going to talk specifically later on.
Yes, I know.
But we're talking, let's talk general. How does it work? How does it work in the real world?
If it's an election allegation, then it's dealt with by my team. If it's something that actually we feel this is not an electoral offence, so I've already alluded to it, may be that it's actually a hate crime offence, then we will speak to the relevant borough or the relevant unit, and they will then take over the investigation of that crime. So it's not everything doesn't come into the Special Inquiry Team and never goes out again.
Yeah. Are there times during a complex investigation where you might seek other people's advice? Like in other investigations, you'd bring in, if it was going on for too long, you might give a review or ask other officers' advice in terms of how it's developing, how it's proceeding? Does that work? Does it happen? Has it ever happened in any of these cases you've had since you've been established?
So the short answer is yes. So as well as the investigating officer and their immediate line manager, so for some of those complicated cases or when the scale of the investigation is relating to a particular election, there will be the additional level of oversight. And I know we're going to come on to the case study later, we can go through some of that in more detail. There are other cases, so an officer out in a borough has an allegation that is made to them and they think, well, this is connected to this election, it will automatically go through to the special inquiry team. You've heard about what might happen, for example, around a hate crime offence, might go back for a local investigation, but there could be other offences. So if it's fraud but not related to the election, so we have dedicated fraud specialist officers, within our serious organised and crime command. So those investigations would go off to the most appropriate person to investigate. But in terms of the review process, there is different levels of escalation that we can do. Not just, so Gail's role as a detective inspector, but that's overseen through to a deputy superintendent, then ultimately through to myself as the chief officer responsible as well.
And I suppose just in terms, just for us, just to try and understand this, is there equivalent to, in terms of balancing up the role of prevent in terms of this offence, criminal offence in terms of democratic practices, is there equivalent to cold cases? So somehow, the leadership that you have at that time, a fresh pair of eyes might look at it and then say, well, actually, now we're going to look at it in a different way and tackle it in a different way. So in some of these cases that have not been disposed of, are they still live? And could they still be live in terms of your unit? Do you have live cases now, historical, that you haven't quite but they're still on file? Or how does that work?
So I think it all depends on the offences. So as you're aware, there are, when it comes to particular election fraud and malpractice offences, there are time limitations. So in terms of a live investigation, once that time has expired, then clearly there will be no ongoing live criminal investigation for that offence, but there could be other offences. We have a number of ongoing investigations relating to different elections, and it's a whole myriad of investigations that we have around those different offences at this point in time. I don't know if that answers your question.
And then I suppose, well, it partly answers it, but we might come back to that and return to that. Then let's just talk about this relationship between you and the CPS. So am I right in thinking that if I'm an investigating officer and I need to pick up the phone, I'm going to make a file note of that conversation with CPS, and presumably you might do it at the other end, but doesn't it work like that? Is it not straightforward? What's this, these conversations of how they take place, who does what, what's this sort of process like? Can you describe that progress with us, both like during an investigation and then when we finally get to the little bit? Because we'd quite like to hear that and understand that, because it might have some relevance later on. So how does that work then?
We talk from the police perspective.
First, to do the police and we get the CPS one.
It's a very broad question, but the contact with the CPS can be at face-to-face meetings, it can be on the phone, it can be by email, and as police officers we do take notes and record things, so that would be recorded that you've had the contact. But it may actually be documented anyway because you've got the emails or what have you, but there's no set specific, they must be contacted in a particular way. But the guidance, the Electoral Commission's guidance makes it very clear that in relation to election offences, it must be each police force's SPOC who makes that contact, and it's already been alluded to, there are the two particular specialist lawyers in the both parts of the country, so the contact is made with them direct. So they're the two lawyers, so it may be that we meet them. We're based in London, so we can meet them face to face, by email, or we may be submitting formal paperwork.
Okay. Is that how it works?
Yeah, that's a fairly accurate description. We have two, what we call senior specialists, I suppose, one in York and one in London, but I have more lawyers in my team who will advise and make decisions on election offences, and they would be mentored and trained and supervised by the two sort of recognised specialists, I suppose. So we have succession planning, and so I wouldn't want there to be any concern that there's only two people in the country in the CPS who knew anything about this. The process is fairly organic. Once we're notified of the offence, we register it on our own systems, we allocate it to a lawyer. That lawyer will make contact, or contact will already been established. We'll see what advice is being sought, or proactively what advice we would choose to give at that stage. There isn't really a rule book for this, but obviously we respect the independence of the police to conduct their investigation and make their own operational decisions, but they will often need help from us to identify what precise offences we may be looking at, because that might not be clear from the outset, and what the elements that need to be proved for each offence, and therefore what evidence we would suggest they go out and look for. At the end of that process, and of course it depends on the complexity of the case as to how long that takes and how many meetings, whether there's a formal submission for early investigative advice, as Commander Cundy referred to earlier, or whether it's more just the exchange of emails, face-to-face meetings, which are all noted on both sides. There's a decision for the police to make at that stage, assisted by our advice, as to whether they think it's crossed the threshold to be referred to us for a formal charging decision. Now, I don't want to get over legalistic about this, but obviously decisions can be challenged, local appeal procedures, or indeed challenged in court. So the identity of the decision maker is important, but I don't want to get hung up on it because we work very closely. So sometimes the police will decide, based on our advice or assisted by our advice, actually they don't think the threshold is passed, so they will NFA it, colloquially, decide not to refer it, or they will say they think it's passed, and then we make a decision, and we either charge or we don't.
I noticed on one of these is where you obviously make a decision or come to a view that one of you wants to go forward into a court, and then you get into court and you offer up no evidence. Is that there is in the documentation, you might not have it, but the police have appendix A, this famous exchange of letters between MOPAC and the MPS issues, and there is that.
Which case is that? Sorry,
I've not got a specific case. Okay. It's just raw statistics, and for my view, this looks odd and bizarre. Well, we've had this before in these conversations with the CPS about that.
Well, there's one case where we ended up offering no evidence because of the health of the defendant. So a charging decision was made. We all agreed that there was sufficient evidence and it was the public interest to continue, and then the public interest factors changed because of specifically the health of that defendant, and therefore no evidence was offered.
So can I just interrupt? How do you balance that with the prevent criteria of election fraud? I'm very sympathetic. Look, I'm on the left. You know, I'd be concerned about individuals, but I'd also be concerned about threats to democracy and democratic practice. Yeah. So how do you balance that out? Is that a conversation that you take, or is that also with the police?
Well, it's a decision.
How does that
work? It's a decision for the CPS, but obviously it's one that we would only take in consultation with the police. Now, in offences where there's a victim, and I don't want to get into a philosophical debate about whether there's victims for election offences, but just to give you a concrete example from other kinds of cases, if it was an assault or a rape or a theft, where there's a victim, obviously we would always consult the victim as well prior to making that decision. Public interest factors, public interest decision are always difficult. In our Code for Crown Prosecutors, it sets out very clearly what factors we would apply, and it's always a difficult balancing act.
We don't know the facts of the case, but if I could suggest, if it was in an area where there might have been a lot of activity of this nature going on,
yes,
would that not could I not be, would it be fair to me, it'd be mildly critical of the authorities if they weren't taking that into account? Well, now, I don't know, and it may well be this is an individual one, and it's not in an area where there are some dodgy practices going on. But sorry, should I not be critical of that?
Well, if it was the case that we weren't taking that into account and we didn't factor that into our decision, then yes, you should be critical, but that's not what's happening. We obviously factor into account the public interest in ensuring the integrity of the democratic system in this country, and part of that would be in looking at whether it's prevalent in a particular area.
I don't hold you to account. We only hold MOPAC and via the MPS, but someone should... It might be worth looking at that case to see if there was some areas of where it was a number of practices rather than one. So I just want to go finally back to the issues. Leadership is very important to both your organisations, and the quality of investigations. And like politicians, we like to think we're consistent, and sometimes we're not. And depending on the time of day, I can work at 100%, and sometimes I might dip down to 50% or even lower on a bad day. So we all strive for consistency, and this great thing called the law is meant to be the consistent bit. But actually, the experience and some of the things we've heard from both the CPS and the police over the many years around this table is sometimes about indecisions, is about leadership and about people with different experience taking a different decision. Yes, it may well be within the law. Is there a factor in some of the cases that you do that other officers, other lawyers might take a different view from that was reached in conclusions? And how do organisations like the MPS, CPS handle that to get some consistency of approach and advice, not just in this matters, but in other matters as well? Because it might be useful to have an answer from you. And how important is that in your checks and balances to come to the right conclusion?
I can deal with it briefly from the CPS perspective. We have rigorous quality assurance of all decision making in any serious and sensitive cases, and election offences are dealt with in my team, which is Special Crime and Counter-Terrorism Division, which reflect the seriousness and the specialist expertise that we think these cases require. So any decision by a lawyer to charge or not charge goes through, well, there's a process before the decision is made that lawyer is supervised, has monthly meetings with a unit head, and then the final decision has to be signed off by that unit head, and if it's a particularly sensitive case, then it's signed off by me. We have guidance, we have policies, we seek advice from external counsel if we're particularly troubled by a point and we think we need further advice. So this is not a case of one person making a decision in isolation. Having said all that, of course, we're lawyers, we disagree with each other from time to time, and different people can reach two perfectly reasonable decisions based on the same set of facts.
I'd say from the police perspective, it's like any walk of life. You can have two individuals with the same training, background, experience, and they might look at something in a different way and have a different view in terms of outcome. I think you're absolutely right about leadership and consistency. The reason we have a small group of detectives investigating these types of crimes is to try and ensure we have the best possible consistency. But for me, what goes to the very heart of policing is about individuals' discretion, operating within the law and making the best possible decisions with the evidence that they have. Every allegation will be different. Every case will always need to be looked at on its own merits, its own set of circumstances, set within whatever broader context that may be there. But some of the other things we do, and I know you alluded to earlier in terms of review processes, that's why we have day-to-day review processes through line managers, escalation, and we have, within all police forces, within the Metropolitan Police in particular, we have dedicated review officers that we can call in for particularly complex or large investigations. We do it as a matter of routine for homicide and other matters.
Okay. Robin, you want to
can I just add serious points really about the role of MOPAC. One is, MOPAC's reassured that there are, and it's a consideration part of our duty to make sure there are review processes in place for specific investigations, though we wouldn't seek to, influence independence. When we concern ourselves with the area and getting an assessment of, what's happening outside elections, what's happening in other crime areas, what's happening in the specialist crime, the specialist inquiry team, that's a classic role of the borough commander here as a focal point, a contact point for the whole borough. One senior leader accountable for that one area who can actually be engaged with partners, find out what's going on, and actually take that overall impression of what's happening. And clearly, for serious matters, we are reassured that there's a process in place within the Metro Police Service, so when a serious matter of this nature happens, there is a goal group structure which ensures that these actions are overseen at the very highest level of the service.
Thank you very much. Okay.
There's just one legal question, just to seek clarification. In terms of some of the activities that have been, where they've been convicted in Slough and Woking, there's an issue that one of the charges was conspiracy to defraud the returning officer, which we understand is not time limited under the People of Representation Act. Is that correct?
That's correct.
That's correct.
Conspiracy to defraud is not time limited.
Oh.
When I asked you about
do the
conspiracy
police
earlier on,
do
could use that. Yeah.
Do you accept that?
Yeah,
It's a law, isn't it?
Yeah, absolutely.
It's
not
not
time limited, no.
It's not quite as straightforward though as well.
Right. I did ask about conspiracy earlier on, didn't I?
Well, I answered your question, Mr.
Yes.
Dismore. This is a different question. It's not time limited. That isn't to say that it's a simple substitute charge that you could use. There have been first instance decisions, so not appeal court decisions, first instance decisions in Crown Court to say that it's an abuse of process of the court to bring a conspiracy to defraud charge when you're out of time on the representation of the People Act charge. Every case is different. They all depend on their own facts, but it's not a simple case of saying, I can't bring that charge, I'll use conspiracy to defraud instead.
But you can bring in a balance of activities and a consistent activities and actions that could make a difference in bringing a charge like that and persuade the courts the reason why you're doing that is because there is a history of activity.
In theory, yes. I mean, just to pick up on something you said earlier, Mr. Val, and I don't mean to be glib, but you can't prosecute an atmosphere. You have to prosecute individuals for specific conduct that you can prove to a criminal standard.
Okay.
So that's always the challenge.
We get that. Happy with that?
Yeah, it's
Happy
very
enough
helpful.
anyway. Right, we now need to move on because we've had guests waiting very patiently up there. I'm just going to suspend and pause for a minute before we bring them in. Thank you very much.
GLA, Chamber, Sound. 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 GLA, Chamber, Sound.
Okay, welcome back. So again, can I welcome our other invited guests, and again, thank you so much for your patience in bearing with us from the first session. So first of all, we have Sir Ken Knight, CBE QFSM, Tower Hamlets Commissioner, Mayor John Biggs, my old comrade, Councillor Peter Golds, CBE, Tower Hamlets Councillor, and Francis Hall, Barrister, Field Court Chambers. And we're now going to address a case study. I'm bound just to read out the statement, if you don't mind bearing with me. Before we begin the discussion, I would like to say that there is an important role for the Tower Hamlets Commissioners who have powers to appoint persons to and remove persons from the statutory offices of Electoral Registration Officer and Returning Officer. It will be important for the committee to hear about the work done by the Commissioners to ensure that the election process in Tower Hamlets can now command public confidence, particularly as the government looks to hand control back to a local authority in March 17. I would like to remind the committee that the decisions of the Elections Commissioner, sitting as a High Court judge, are a matter of public record and can be referred to as such. If there are, however, further allegations of election fraud and malpractice about which determinations have not been made, this is not the appropriate place to hear them. I must emphasise that the Police and Crime Committee is not tasked to investigate specific cases and/or allegations, but is expected instead to scrutinise the policies and procedures under which such matters are or are not investigated. Therefore, as Chairman, I will need to prevent the discussion going into areas which are not within the committee's remit. So I was instructed to read that, and I think it's appropriate to do so for this second part of the morning. So again, can I thank guests for attending this morning, and the next set of questions, which is around the Tower Hamlets case study, is going to be led, I think, Andrew, are you leading this?
Okay, well, this is a question for Mr. Cundy. According to your data, there were 164 allegations of electoral fraud related to Tower Hamlets in the run-up to the elections. And quotes, every allegation reported to the police was recorded and investigated, and advice was sought at various stages from the CPS. That's what you've told us. So can you tell us now what that investigation of each of those allegations consisted of? And as you do so, can you tell us when, time-wise, each of those steps took place?
So, of course, that's 100. So the 164 allegations refer to all allegations connected to the elections in 2014.
The 2014
some were reported in advance of the election day, some on the election day, some subsequent to the election day. I couldn't sit here and say, right, 164 investigations, they all occurred like this, but I can talk about in some general principles to that. So out of the 164, in fact, there were 208 allegations across London on that day, and 164 pertain to Tower Hamlets. In terms of, we were talking, what's the nature of those allegations? If I talk about the Tower Hamlets cases, so 47 of those allegations were about undue influence or intimidation at polling stations. If I do the top three, 27 referred to tampering with postal ballots, and 17 related to ghost voters. Now, as we described earlier, each of those allegations would have their own investigation. And yes, each one was recorded, and then each one would be investigated, particular to the nature of the allegations themselves. So, in relation to, obviously it's not appropriate to talk about individual cases, but it might assist if I sort of describe some of the investigations from an anonymised perspective, explain the types of investigated activity that would be undertaken. So, if I talk about a personation offence, so for those types of allegations, the first steps that some of the first steps that we will undertake will be what do we have about any named individuals, both from our police intelligence systems or crime reporting systems. We would make contact with the local authority, with Tower Hamlets, to identify what they have, and to identify what documentary evidence exists, which you alluded to yourself much earlier. And then each case may follow a different path. So we had one case, without going into the names of the individual, where we were able to identify the individual who originally the information was not in this country when the election occurred. We were able to establish through that person by who the potential suspect is, that in fact we were able to prove that they were indeed in London at that time of the election and not abroad as was first considered. Some individuals within those personation offences were interviewed under caution, and they will identify through those interviews as to what they have to say for the events pertaining to them. And of course that's going to be very, very, very case specific. What we did find, and was alluded to earlier in terms of general about some communities that we have, on some of our investigations, English not being a first language, some of it individuals had misunderstood some of the rules, and indeed one of those personation offences did result in a caution having consulted with the CPS. In terms of imprints, again, as DR Granville referred to earlier, we take those initial steps to, so what is the material? We seize that material, we'll identify are there offences within it, and if the imprint isn't, as it should be, then we'll investigate by going through to the printers, so we're going to make the inquiries with the printers of the leaflet or whatever the material may be, and establish from them who commissioned it, and then we'll go back to that individual who did commission it to make the inquiries of them, and if there have been problems with it, and if the imprint wasn't correct, then that's the consultation with the CPS. We'll identify, okay, so this is sufficient to justify a criminal prosecution, and that's going to be very case-specific, each one according to its merits. I touched on residency earlier, which is undoubtedly a challenge for us from an investigative point of view. So, as part of the investigation into that, now that is trying to define, so what does residency mean within within the bounds of the law, and it's not a strict definition that says if you tick these 3 criteria, it's evidence. So as you will be aware, an individual can have 2 addresses, but provided they only vote once from one address, then they have not broken the law around it. So within the cases where residency was an issue, we, as the Metropolitan Police, and indeed some of our inquiries took us beyond London to other forces, where we were making inquiries at each address and establish the circumstances within that, speak to the individual involved, and try and establish through them, through other documentary evidence, and documentary evidence can be much more powerful than witness testimony when it comes to this, to establish what is the connection to that address and what is the residency around it, and we will use everything from bank bills, driving licences, what's on registers, etc. What we know from a police perspective, again, not unique to London, is sometimes multiple registrations of voters is their purpose is often not for electoral fraud, but for other fraud purposes, and we see that through other fraud investigations, which clearly we can be very mindful of. We had other investigations in relation to multiple voting, and again, it's that similar process. So it's the work that we will do from the police, then in conjunction with Tower Hamlets as the local authority, and in one of the cases around multiple voting, as I think you referred to earlier yourself, there can be certain circumstances where we can secure court orders to go beyond the secrecy of the ballot box. And so on some of our investigations, and one investigation in particular, that's exactly what we did. We pursued the investigation as far as we can possibly and reasonably go, which did include securing a county court order to go back to the original ballots, and our officers then spent a whole day trying to find the individual ballot paper that was required for that particular investigation. And to try and explain that, the lengths that we will go, once the ballot papers are identified, we will then submit it for forensic examination to identify if we can get fingerprints on it, which of course is an ideal aspect of evidence for us. All the way through that process, as you've heard, we will be engaging and liaising with the CPS. So they will give us advice around steps that we may not have considered ourselves. So back to the specialist special inquiry team, the officers there are specialist investigators. They are not specialist lawyers. The specialist lawyers sit within the CPS, which is why we engage and we consult and we get the advice. We get the advice from them. So of those 164, there were investigations that were conducted. You have in the material which has been provided through to the Deputy Mayor the outcomes of those. So when it comes to an outcome decision, we will always consult with the CPS on that to make the charging decision is a matter for the CPS. But again, with their advice, there are a number of individuals who received warning letters or words of advice from us as the police, in addition to the charge of one individual and the cautioning of 2 other individuals.
So what was the timetable for these investigations?
So the investigations, some would have commenced before Election Day in May 2014, and others would have commenced on the day and then subsequent.
And how many witnesses did you interview?
I haven't got the figures for in 2014, but I know in the review in 2015 we interviewed in excess of 70 witnesses.
Right, but you don't know how many you don't know how many you did in 2014.
I haven't got the. I wouldn't like to mislead you.
But you do have that record, presumably.
We have
back
the
at
record.
Back at the office, right? Okay. So you can let us have that figure.
Yeah. So every single one of those 164 allegations received an investigation. Some would have been much more comprehensive than others by the very nature of what they were, the serious nature of the offence.
Okay, so we then come to the election court, which Mr. Murray QC gave his judgment on the 23rd of April 2015. And he said, not very pleasantly about the Met, an unkind person might remark that the policemen and polling staff had appeared to take as their role models the legendary 3 wise monkeys. What do you say to that?
So that was very particular to what was occurring at polling stations, and in the preceding paragraphs of the judgment, he refers to, in essence, what were 2 halves in terms of describing the events that occurred in there. As you say, that doesn't just refer to the Metropolitan Police, that also refers to the polling staff on the day as well. So we had officers at each of those polling stations, and they were talking in general terms earlier. So it's a phrase that Judge Moore gave us, and I think the Commissioner was before yourselves in May 2015 and I think it's on public record, the letter that Judge Murray indeed wrote to the Commissioner with his views of the Metropolitan Police, and that his judgment was not intended to criticise the Metropolitan Police response. But yeah, I do accept, and it's back to what we were discussing earlier, the role of police officers at polling stations does need them to be aware of electoral offence matters, to understand what steps they can take. I know how I would be as a young police officer standing at a polling station, where my only experience of that is going in to vote myself and thinking, if I do something, am I going to be judged as trying to impede the free and fair elections, which is why, particularly when it comes to Tower Hamlets, the work that we've done with the local authority, the joint training between our officers and the polling station staff to try and prevent that type of activity and make it clear what the individual roles can be.
We've also got a memorandum from Mr Earlham of the 11th of January this year, and he says 6 days before the election court case, the police tried to arrest him as a suspect for seeking to pervert the course of justice, although later admitted there was no complaint nor even a bogus one about this. What was all that about?
Well, it'd be highly inappropriate for me to talk about an individual investigation around any person. What I can say for the record is that Mr Earlham has not been charged or convicted in relation to any offence relating to these matters.
Okay, well, we then come to the election court, and after the election court's judgment, it's not a report, it's a judgment. Judgment,
yes.
What happened next? You sought an extension to the time limit.
Yes. So,
what happened after that?
And Nick Vamos can articulate much clearer than I. So within the RPA, the Director of Public Prosecutions can refer offences to the police to investigate. His Honour Judge Murray, within his judgment, or indeed in court, did not make any direct referrals to us as the Metropolitan Police, or indeed to the DPP themselves. We did not receive any referral from the DPP for any matters to investigate. But, and I know not many will not necessarily agree with this statement, we as the Metropolitan Police fully understood the serious nature of all of the offences and all the allegations that were pertaining to Tower Hamlets. So we ourselves did our review of that 200-page judgment to identify if there were new offences, or indeed if there was evidence in there which we had previously been unaware of. So that was a review process. So back to what Mr Duval was asking earlier about review processes, that was a critical point in time as part of our ongoing investigation. We identified with the time limitations we would need to go and get an extension, which we did. We brought in a new detective superintendent and a new investigation team who were not involved in the original investigations pre the election court judgment, and we identified 5 new offences, or 5 new allegations. One of those technically was out of time, but we investigated it anyway. And we also identified, so just referring to make sure I get the right figure, 47 cases which we had previously had reported to us and investigated, which in reality related to polling stations where we considered there might be potential new evidence. So we then, as the Metropolitan Police, commenced another investigation or re-investigation, whether it was new offence or the other matters, and then went back again. So in terms of the 5 new offences, I mentioned one that was out of time, but we still investigated it nonetheless to see if we could identify any other potential offences, and the other 4 offences, which included an allegation of perjury. Each of those was individually investigated by new officers not connected to the investigation, as I explained. And out of the 47 cases which were re-examined, re-investigated, we made inquiries in relation to every single one of those. So there were 37 potential witnesses, 36 potential witnesses pertaining to those 47 cases. 29 of those individuals were willing to speak to us. None of those new inquiries established new evidence that would enable us to go for a charging decision to the CPS. What we did with those post-judgment investigations, new or re-investigations, was close consultation, getting advice from the CPS along the way, all the way through them in terms of making the best informed decisions.
I think you interviewed 70 witnesses?
I spoke to 70 witnesses.
Spoke to. How many statements did you take?
So, as I alluded to earlier, so that what we did encounter, there were a number of witnesses who gave evidence within the election court who were unwilling to give statements to the police as part of a criminal investigation.
But how many statements did you take?
So I can get that figure for you if you wish, Mr Dismal, we can provide it.
I think that would be helpful.
Andrew, Mr Hall wants to come in, I believe. He signalled.
Yeah, well, I'll just ask this next question and then fine. Again, I'm going back to the memo from Mr Earlham. He says in June 2015, he personally delivered 2 files of evidence of fraud in Tower Hamlets to the Commissioner in New Scotland Yard, together with the names of about 20 witnesses, prepared to help the police with any inquiries. He says, I have never heard from the police, now I have the witnesses, to my knowledge. What happened to those files and the people he identified?
So I have it before me. The documentation that Mr Earlham provided included a list of 17 witnesses. We spoke to every single one of those 17 and in fact identified another potential witness to the matters that he related to us. Some of those witnesses were unaware their names had been put forward via Mr Earlham, but every single one of those was spoken to.
Sorry, Mr Hall.
Yeah, it's really a response to that answer by the Commissioner. There was actually, I note that the Commissioner didn't mention in the 160, I think it was, other additional offences that were identified in the judgment, electoral expenses offences. Now, the Commissioner will be aware that the petition, which I presented to the election court, didn't allege election expenses and couldn't have been amended to allege them. Nevertheless, it's of note, and the Commissioner should note and will be aware from the judgment, that at paragraph 533, Commissioner Morey notes that the guest of honour at a meeting at the Gigrotto rally hosted by an organisation called Gigrotto at the Water Lily on the 4th of May 2014. The guest of honour was Mr Rahman. The event was avowedly a political rally in his support. There were videos of that meeting presented before the election court. In addition, there was a Facebook reference to a speech by one of the people there, heavily in support of Mr Rahman, who was cross-examined and accepted that he had given this speech, which was supporting Mr Rahman's re-election. At 3,394 of the transcript at the 5th of March 2015, which was something which was referred to in my submissions to the Commissioner, Pura Mir, who was the manager of the Water Lily, gave evidence that the usual rate for 2 hours was £750, £350 were paid by Gigrotto. Mr Golds, Councillor Golds, in April, or I think May, shortly after this meeting.
Remember, we are not sitting in judgment.
No, I understand that.
My earlier statements.
I understand that, but the point I'm making is this is evidence of an offence which was within time at the date of the judgment. And in addition, I understand that all Representation of the People Act offences were given the extension by the Magistrates Court before the expiry. I think that's right. Is it, Commander? Or was it in relation to specific offences?
It was in relation to specific offences.
Right. But in any event, the date of the judgment was well before 1 year after the election returns were returned. Now, that meeting wasn't declared. So that's one piece of evidence of potentially an electoral expense non-declaration, which could have been prosecuted. Of course, Mr.
If I may, Chair, on that point.
I'd rather you didn't have conversations across like this, but do you want to respond?
Right, but something that didn't feature in those offences that were supposed to be.
We understand the context.
So without getting into the individual investigations, so the Metropolitan Police was not a party to the election court. The Crown Prosecution, or the DPP, had a lawyer within court to listen to the evidence. So the Metropolitan Police is not sitting there listening to that evidence. So we did not get any allegations referred to us to investigate ultimately via the DPP from within that hearing.
We have got a set of questions about burden of proof.
It begs the question then, did your review throw that up? Did your review throw up?
I can say that the event at the Gigrotto was one of the new offences that we did investigate.
You can't say it was, right?
I can say.
You can say it was.
And I think for the record, because this is a public record, the judgment is a public record, as we know. So the 5 offences which I referred to, So within the judgment was in relation to 37 Cavell Street. The case that's just been referred to by Mr Hoare and D.I. Granville, one related to a false statement of fact as to candidate. That was the one that was out of time, but we investigated nonetheless. And then there was in relation to polling stations I've talked about. And yeah, there were 3 allegations relating to undue influence.
Okay.
And the perjury allegation, which I mentioned.
Okay, well, we'll go into some of the details of this later on, and probably go into more into Mr. Gold's memorandum, Mr. Gold's memorandum shortly. But can I just sort of follow the timeline, as it were? So you've done this further review. Why, despite the election court's findings and your subsequent investigations and all the things you were doing, weren't you able to secure the prosecution of any of the respondents to the petition? Bearing in mind, we could also look at the issue of conspiracy, for example, which I referred to earlier on, and we've had this exchange with Mr Vamos about that with Mr Duval as well.
So, Mr Diswell, we can only go where the evidence takes us.
Yeah.
You know, these were comprehensive investigations to try, some, as I alluded to, some getting county court orders to go and secure particular, ballots that were cast on the day, votes that were cast on the day, should I say. So, I know it's been talked about the difference in procedural rules between an election court, which is primarily a civil hearing, where the judge is sitting there, and as Judge Maury explained his judgment himself, early on in the judgment. So he has an inquisitorial function. I think as he describes it, some way between a civil court judge and a coroner. From a criminal investigation perspective, the rules are quite different. We talked about hearsay earlier this morning, and I think that's just one aspect of it.
Yes.
And of course, we must prove beyond all reasonable doubt.
He's waiting to come a standard of proof, but he can take hearsay evidence. You can't take hearsay evidence.
I think hearsay evidence is one element. It's not the only element within it.
Okay. So you're saying there was insufficient evidence to put before the CPS to found a prosecution, or did you put the evidence to CPS and they decided there was insufficient evidence? So
we talked about it in general terms earlier. I can now talk about case specific. So for these allegations, there was ongoing engagement with the CPS right from the very start with the investigations, as was described earlier, which is regular contact. Individual files for a charging decision were very few, because that getting to that point, that would be the CPS would know all about cases before it got to that point in the first place. So it's not, as I described earlier, it's not like a police investigation into a theft where you'll put one file in on the case if we think it passes the threshold test in relation to a charging decision, and then the CPS will do the test that account for the code for the Crown prosecutors. So I lost track of what your original question was, Mr Dismal.
The question is why no prosecution?
Well,
and was that decision taken by you or by the CPS?
Well, the decision to prosecute would be the CPS. The decision for a lot of these individual cases, as was explained earlier, there always needs to be clarity. It is a police decision if we do not consider there is enough evidence to pass that threshold test.
Okay. So then we follow through the timetable, and there's a hearing before the Lord Justices on appeal from Mr Rahman. And then in July 2016 there's a meeting with Assistant Commissioner King, attended by Mayor Biggs, the Chief Executive, Mr Goals, 3 commissioners, I don't presume that includes you, Mr Sir Ken, D.I. Granville and Mr Vamos. What was that about?
So that was a meeting, literally as you've articulated. So in the March of that year, looking at my timeline, so following the advice which we had received as a police from the CPS from a meeting we had with them on the 18th of February, on the 16th of March, the MPS put out its press statement, which made it clear that following the review of the judgment and the new investigations, the re-investigations, that no individual was to be charged. That meeting in the July was with those individuals as you have just described them, to endeavour to explain what the MPS had done as part of the investigations and the reasons the decision had been made.
Sorry? Who said something just then about a decision being made?
And that was me speaking.
Okay. Why weren't the petitioners invited?
So I can't say personally why the petitioners weren't invited to that. I mean, Mr. Earlham, as you've read out and stated, he was under investigation. I think one of the things having...
You were still under investigation in July 2016?
So, no, so just about to get on to. So, Mr. Earlham has said that he was under investigation. The petitioners were not at that meeting. And so in terms of review process, so as the new chief officer with responsibility for electoral fraud matters in London, I think one of the things which has not gone well from the Metropolitan Police perspective is to try and explain, as you've just asked me the question, the whole process and why the outcome is what it is. And I think we could have done more and should have done more in terms of engaging with the 4 petitioners before and after that judgment.
Mm-hmm. Okay, Mr. Vamos, do you want to think? Have you read the judgment yet, Mr. Vamos?
Well, I'm very glad you asked me that, Mr. Dismore, because Mr. Golds has very fairly set out the correspondence that he and I had in his letter, which I've only just seen today. The specialist prosecutor who advised the Metropolitan Police throughout this process not only read all of the judgments, she got daily transcripts and regular reports from the council who we instructed to attend the petition. What I said, which was I volunteered at the meeting in July, contrary to what Mr. Earlham seeks to suggest in his letter that has been somehow winkled out of the CPS, is that in advance of that meeting, although I hadn't read the whole judgment, I'd been fully briefed by the specialist prosecutor. So that's the explanation for that comment, and I'm grateful to Mr. Golds for setting out our correspondence in full. I didn't think it was such a big issue, but obviously it's been misinterpreted since I said it.
Right, okay. So the purpose of that meeting in July 2016, presided over by Assistant Commissioner King, was to try and convince everybody else that you'd done your job right. Is that it?
Probably your words rather than mine, Mr. Dismore, but it was part of that engagement with some of the critical stakeholders connected to the case study that we're talking about today.
Do you think you got the message over?
No, I don't.
Okay.
Definitely don't. And that, as I said a few moments ago, I think so. Having come, talk about fresh pair of eyes, you come into this as I did with a fresh pair of eyes, very much post event. I think there are some things which we could have done much better in terms of that communication engagement with a number of different individuals.
And as far as inquiry is concerned, obviously there are a lot of criticisms in Mr. Gold's memorandum, some of which predate the 2014, refers to specific officers, though not by name. And I'm sure Mr. Golds would give you the names if requested, should you wish to follow those up. But Mayor Biggs wanted to comment.
I just wanted to record that I think all of us came away from that meeting rather confused and frustrated that the record of actions from the police and those of the CPS didn't seem to coincide with each other. So we came away with a clear impression that it was Assistant Commissioner King, I think, wasn't it? That she was very clear that the Met had passed all sorts of information and recommendations and conversations to the CPS, and the CPS didn't seem to have the same recollection of what had happened. It left us wondering what had actually happened with the case.
Can I come in on that, please? Because there obviously is confusion over this, and I think it's well, I would say it's a red herring, but I think it's very easy to clear it up, and it's really what Commander Cundy and I have been saying from the start, that the CPS and the Metropolitan Police worked side by side in these investigations. So though from a legal perspective it's important to identify the decision maker in terms of then whether that decision can be challenged, we agreed with the Metropolitan Police decision not to refer the files to us, and it was informed by the advice that we had given them throughout. So if Commander King and I didn't explain that satisfactorily at the meeting in July, then I hope we've done that, Commander Cundy and I have done that today, Assistant Commissioner King I should have said, and in subsequent correspondence I hope we've tried to make that absolutely clear.
Well, Chair, can I come in at this stage? I think it's really important to clarify this point because well, on budget day, the press office of Scotland Yard issued a press release basically saying that after full consultation with the CPS, a decision had been made that there's insufficient evidence that criminal offences had been committed. Jim Fitzpatrick, the MP for Popular Limehouse, was told by the CPS, and I don't know who within the CPS, I should have found out, right, but he was told by the CPS that they had never seen the file. Right.
So it's important to be precise about the terms we are referring to here. As Commander Cundy said, I think, at some point during the first session, when we talk about a full file being received from the police, that's a term of art referring to a file of evidence that the police have decided discloses a realistic prospect of conviction, and they are referring it to the CPS for a charging decision. So at that point, the responsibility for the decision passes to us. We apply the code for prosecutors, and we make that decision. So I don't know who said that. I'm not quite sure where it's from. I'm very happy to look at it. But
I shall certainly provide you with that information. Term of art. That's an interesting phrase.
Sorry.
You just used the words a term of art.
Yes.
What does that mean? What does that mean?
Right. I'm trying to define for you what we mean by a file in that context. It means very specifically a file of evidence which the police have assessed discloses a realistic prospect of conviction that they are then passing to us for us to make a charging decision. So we did not receive a file in that sense because the police had already decided not to refer. That is not the same as saying we didn't ever see any evidence, we didn't have exchanges of correspondence, we didn't discuss endlessly and frequently the evidence in this investigation.
But in the end, therefore, it was the police's decision not to prosecute.
Correct.
What is the key point?
Sorry. Again,
you acted on
the police's decision not to refer a file to the CPS for us to make a decision.
So de facto, as far as the public is concerned, that means the police made the decision that this wasn't going to go anywhere. Let's put it like that.
Or can I put this, that you acted on the police's assessment of the situation?
Excuse me?
You acted on the police's assessment.
No, they didn't have to act because it
wasn't... or failed to act, rather.
No, they didn't have to. It never got to them. That's the point. Ultimately, it was the police who made the decision that this is not going to go to CPS for prosecution. So the decision about all this was made by the police.
I think that's a clear point that we've just gauged now. But we have got a set of questions about burden of proof. But Tony, did you want to come in?
Yes, it was precisely on that point. This is the first time we've heard about this, so to speak, continuous conversations between the police and the CPS. One of the catalysts for this meeting was when we had the deputy here, we also had a letter from the commissioners referring to the fact that the police hadn't referred the matter to the CPS. The deputy said that he believed, he understood that the matter had been referred by police to CPS. Subsequently, I think in Parliament, Eric Pickles asked the same question, and there appeared to be a similar dispute. It's clear, is it not? I don't know really who to ask this, perhaps Mr. Hall, that in this case the police and the CPS were one.
Well, as I've already said, we agreed with the decision that the police made, and it was informed by the advice that we gave them.
So,
and I've said that on previous occasions, and I've said that at the meeting in July.
So, are you telling us that what happened was the police came along and said, "Do you agree that we haven't got sufficient matters for you to take the matter any further?"
No.
Is that what happened?
No.
Well, then how did you come to this agreement? Are you saying the police didn't come to you with any kind of recommendation at all? They said, "Here's the papers, Mr. Vamos. Do you agree with us that shouldn't go any further?"
No, we came to it in precisely the way that I've described on several occasions already this morning.
So they asked your advice and you gave them advice, and in the end they decided not to send you a file for a decision.
I think that's a fair summary, but I wouldn't want to speak for Commander Cunliffe when you think that's a fair summary.
I think that is quite clear, though.
On record, yeah.
It's kind of, could you want to put briefly, because we are moving on to...
Is that a fair analysis?
No. Is that fair? Just your confirmation, is that a fair analysis?
Just repeat that statement, because I'm not sure the statement itself is...
Okay, well, the statement was, you were in discussion with Mr. Vamos or whoever, the CPS were giving you advice, and on the basis of the advice and the discussion you had with the CPS, you, the Metropolitan Police, decided not to refer a file to a formal file to the CPS for a prosecution decision.
In the majority of the cases, yes.
That's question. Well, just one more question. Commander Kandhi, you talked about, or rather, and this is also in the appendix to the letter from the the letter that you sent to the Deputy Mayor about someone being cautioned for impersonation?
Yes, if I just get that document up, if I may.
Right. Now, I can't, well, this is one of the most serious sort of matters that issue that could undermine confidence in the democratic process, a matter of this nature. Where was the decision to issue a caution made? Was it done at police level, because inspectors can authorize a caution? Or was it done in consultation with...
So to be really clear, the decision to give a caution is only made after consultation with CPS.
Right. Now, I know that each case varies in specifics. You've got to look at the age of the offender, whether the first-time offenders, there's a code for Crown prosecutors, and there's also reference to when police caution should be issued or not issued, or whether there should be a full-scale charge. Yes. But a matter of this nature, impersonation, that's one of the most serious offences that undermine confidence in the electoral, indeed in the whole democratic process. Why a caution? Why not a charge?
We talk about individual case, but you need to ask that of the CPS, because that's a decision that comes from the CPS to us. So as part of, there are other investigations within the ones that we've referred to, where individuals, receive warning letters or word of advice, which is below the level of caution. It's not a statutory.
I just have to say to you that this one case alone, for me, it illustrates exactly what's gone wrong with this whole sorry saga.
Well, we're now moving on to a set of questions, particularly around the point, which is around burden of proof. Now, Umesh, do you want to start this debate? This is on that particular question. It flows quite nicely from what you were just saying.
Question to Peter and to John. Can you tell us about your experiences of making a complaint to the MPS about electoral fraud?
I personally haven't taken complaints to the MPS about electoral fraud. I felt because of my role as a candidate and arguably a competitor with Mr. Rahman and others, it wasn't really appropriate for me. Otherwise, I think one of the problems with the electoral accusations is sometimes they're a sort of proxy battle that should really be fought through the electoral process. So I sort of kept out of that, but I've observed the process very closely.
You may not have made a specific complaint, John.
Well, okay. I suppose I'm a man with several heads on, I suppose, and one of them is then I'm the properly elected executive mayor of Tower Hamlets, and I know that there's a lot of anxiety in Tower Hamlets that people feel that there hasn't been a proper closure of this matter. An example of that, I guess, would be what we perceive to be the confusion between the CPS and the Met about who said what and who decided things should be progressed. The feeling that the electoral court judge was very unequivocal in his findings, and yet nobody seems to be held to account on a personal level through the criminal justice system. And I suppose I'm expressing on behalf of a lot of my constituents a frustration about that and a feeling that it wasn't taken assiduously and seriously. I'm interested to hear today about how many people were questioned. But I mean, if you could think of I've spent quite a lot of time thinking about this. If you think, for example, of postal vote fraud, I mean, the electoral court judge found that in his view there had been such fraud, but that doesn't mean that he could identify individuals. And I guess people might be interested to know what efforts were made to try and identify individuals who might have carried out that activity. And I think we're all aware of people who might have been expected to be questioned about this, including people who felt they had evidence about it, very few of whom seem to have been asked to give statements.
In fact, before I bring you in, Peter, can I actually put that question to you then, Commander? There were very many people who just heard from John and other sources and correspondence we had from various parties, people who wanted to be interviewed. Why were so few, if any, interviewed?
I don't agree with the statement that so few, or if any, were interviewed. A lot of people were interviewed as part of the overall investigations, both before the electoral judgment and indeed afterwards as well. There may be, and I want to speak to Mayor Biggs and others outside of this around particular individuals. There was, as I say, there were some individuals who gave evidence at the petition hearing who we approached to speak to us with information that they had. Some of those refused to speak to us. Some of those did speak to us, but wouldn't give a statement for criminal investigation purposes.
Peter, can I bring you? So, Francis, did you want to?
Well, I think this is relevant to this issue because it concerns evidence, and a lot of what the Mat has said in the past about this issue has been relating to hearsay, and a lot of evidence was given by hearsay which was eligible. Well, of course, there's a large body of hearsay evidence which has always been admissible in the criminal courts, even before the 2003 Criminal Justice Act, which includes business hearsay, and that includes, for example, grants that were given, and the decisions that were made, meetings that were held, and so on. If you look in the judgment, which of course the Met has studied assiduously, I'm sure, between paragraphs 460 and, paragraph 525, the Commissioner goes through in great detail evidence, most of which is evidence that is business hearsay, which would be admissible in a criminal court, about the grant process. He also analyses in detail the evidence given by a witness, Deborah Cohen, an officer in Tower Hamlets, who he believed and who gave evidence of 2 meetings in which the Mayor, Lutfer Rahman, and the his agent, who was at that time in charge of the finances in Tower Hamlets, they both denied these meetings took place. He goes through the evidence, the documentary evidence that she gave of those meetings, notes taken contemporaneously, and notes taken on the next day in a meeting with her manager. And he said at paragraph 479, having heard the evidence of Mr. Cohen, Mr. Rahman, Mr. Assad and Mr. Chowdhury on these incidents, I have not the slightest doubt that Miss Cohen was telling the truth and that the 3 men were quite deliberately lying. That raises an additional issue of perjury, of course, which is a matter that doesn't appear to have, it is definitely something that was referred to the police. I know for a fact it was referred to Gail Granville. I also know that Miss Cohen was spoken to by the police. No proceedings have been instituted on that. I note also that the Commander has said that of all those new offences that were brought to the attention of the Met through this judgment, he has not mentioned the offence of bribery. And of course, the Lutfer Rahman was found guilty of the electoral offence of bribery. And in the judgment, the Commissioner also noted that the 2010 Act offence of bribery would also have been met by the evidence that he assessed and found proven to the criminal standard. And so it's not for me to question the Commander, but it might be that members of the Assembly might want to ask questions about that.
Chair, I'm willing to
Okay, we're quite capable of framing our own questions, but that was most instructive of this. Did you want to continue your...
Well, I wanted to bring
Peter.
You ought to answer that allegation.
There are a number of observations here. I should declare one particular interest, and I was very pleased when I heard Assembly Member Dismore earlier this morning, having been a former qualified agent. I had, and certainly Mr O'Connell and Mr Arbour and Mr Prince know that I've been an agent both professionally and voluntary. I was a professional constituency agent for 17 years. I know how to fill a form of election returning. And there are a couple of things before I move on where we've heard, and I have to say, Commander Cundy, a slight movement of the actuality. You have said we have to, on a nomination paper, we have to test residence. Actually, the nomination paper at the top says, and Mr Dismore will know, home address in full, not residency, home address. There is case law on this. I was approached by one of your officers who, on one of the only 2 occasions I've ever been asked for a statement, who spoke to me at great length and said, I don't understand the law in this, so I wrote him the case law. He then investigated the person we were talking about and produced the letter which I think reduced the election court to hysterical laughter. Because here it is, and on the fraudster, he couldn't put his address on. Because, of course, if he put his real address on, it would have confirmed it. And if he put his false address on, it would have done something. So he actually wrote to a fraudster without an address on. Presumably he stood outside Bethnal Green Police Station handing around saying, would you like a letter saying you're going to be let off? Let us now turn to the imprints. And let's turn to imprints. And the police officer at the end mentioned this. And I'm not talking about thousands of leaflets where an imprint gets left off. During the beginning of this election,
there were tens of thousands of A3 multicoloured leaflets produced, folded into three, full of pictures, and it said on the bottom, printed and published by Alibor Chowdhury of 5 Jubilee Street, East 1. Well, that's his mum's house. Now, if he had in his mum's house a mainframe printer that can print tens of thousands of multicoloured leaflets, the poor woman would be dead now because she'd be dead of the smell of it.
It's a lot of them.
And she's not, she's alive and there's no printer in the house. So I wrote to Sir Bernard Hogan Howe, I explained the election law, and I put the pitfalls on because there are two things of defrauding an imprint. One, you're using it for money laundering because you can actually say, I printed these leaflets and spent 10 quid on it. Or you can actually have the printer and know you spent 10,000 quid on it. And that is the one thing. Or the other one is you're getting a mate to print them for you, and of course they're doing it in goods in kind, both of which are illegal. And I wrote to Sir Bernard Hogan Howe, I enclosed the leaflets, I identified the law, never heard a thing. Until eventually somebody called, I think by name of somebody, D.S. Smiths, and said, oh, we've spoken to Mr. Chowdhury. He's not going to do it again. Let us now turn to the things of bribery. And if you look at the Commissioner's judgment, we talk of the bribes that were given to TV channels. And at the beginning of it, it says, in answer to a member's inquiry. Now, the member concerned was me, and those who don't know me know I'm pretty thorough, and I'm known for writing detailed letters. I inquired of how much money was bunged to these TV stations. I got the result. I wrote to Ofcom. I had witness evidence of every broadcast, how much was given by the council, etc., etc. Ofcom censured the council and said this was illegal. And it is illegal to put adverts in favour of, effectively, a governing official on a TV channel that was said to be illegal. Ofcom said that. So I duly wrote to Sir Bernard Hogan Howe and I enclosed everything, including the Ofcom judgment in all its details. I never had a word. Now let's turn to the Jagrotto event. I was handed a copy of the advert to this. So I wrote in May, 2 weeks before the election, to Sir Bernard Hogan Howe, pointing out, 1, the meeting was taking place. 2, the only guest named was Lutfur Rahman. 3, that if it were a public meeting, it had to be declared as an election expense. 4, in the event of it not being an election expense, if it were a joint meeting, everybody else would have been invited. So I rang up Mayor Biggs' agent, Chris Weavers, and Chris had heard nothing from it. So I contacted the UKIP agent. The UKIP agent had heard nothing from it. I contacted the Liberal Democrat agent. He had heard nothing from it. Sadly, for Assembly Member Berry, I couldn't get hold of the Green, but I got hold of all of those. None of them have heard anything from it. This meeting took place, so I wrote to Sir Bernard Hogan Howe and told him of the event, and surprise, surprise, I heard nothing. Now, after the election, I had all of this material. I would have given admissible witness statements, if necessary, in a police court, accompanied by a lawyer, that would have been admissible evidence. Nobody asked me for it. Furthermore, I had corroborative evidence. If you look behind you, Commander Cundy and your colleague, your police colleague, there are people sitting there who would have given admissible evidence from my party, from the Labour Party, and from no party, all of whom witnessed it and knew what. Names were given to you, and not one of us has ever been asked to provide a witness statement. So where's your investigation?
Councillor, I'm now going to give... This is really, really helpful.
Sorry,
we're in a minute going to give the opportunity of the Commander to respond.
Let him answer.
Well, I think, Commander, there's a question from, through us to you from Francis, and also the points raised by Councillor Peter Gold. But can I also put it to you that what you said in your letter to MOPAC, do you still stand by the fact that where you said no evidence has been found of an orchestrated system of electoral malpractice, either by geographical location, for example, Tower Hamlets, or by any specific political party? Do you still stand by that statement? Do you still stand by the other point you make in the letter? In relation to electoral fraud and malpractice allegations in Tower Hamlets, the MPS has been both robust and proactive, because everything heard so far suggests the contrary.
So, in relation to the first statement, so bear in mind the police role is in relation to criminal offences. So yes, I stand by the statement from the criminal perspective, yes, that is our role. That is not to say, from our perspective, there might be views around something that has been widespread, but we have to follow the criminal investigations and the evidence for criminal purposes, and that is our function. Sorry, and the second...
The points made by Mr Hoare and Mr Goals,
yeah.
And the follow-up question from Mr Vamos, did you know that these people hadn't been interviewed?
So, so the purpose of today is not to go into individual investigations. You know, I have legal disclosure obligations that I cannot share certain things for obvious reasons, and all of us in this room, particularly Mr Hall, will be aware of that. The perjury allegation, which was eloquently put by Mr Hall, was fully investigated. He's already identified that Ms Gowan was spoken to. The outcome of that investigation, I will not go into the details of it, did not identify sufficient evidence which we could take to the CPS for a decision to charge an individual. That is not to say that the finding of His Honour Judge Mowry wasn't the correct finding in terms of what he found in relation to that particular set of incidents.
See,
why wasn't Mr Goals interviewed? He's told us he wasn't, so there's no secrecy or about that. Either he was or he wasn't. He would know if he was. He sounds like he's got a lot to say. Why wasn't he interviewed?
He could be here for the whole day.
Sorry. I don't want to get into individual circumstance.
We are in regular contact with Mr Gold and some of the individuals who are here who are saying they...
It says you're not.
If we, as a committee, if we sense that there's been some issues and shortcomings, we will reflect on them in our report. That may well be...
And I'm willing to, and Council Goals will be aware of this. So having come in and used that fresh pair of eyes which I've had, I don't think some of the engagement, some of the key individuals, and Council Goals is definitely one of them, has been appropriate, and Council Goals will be aware that in terms of some of the other offences, not just electoral matters that we've investigated.
Will you interview Mr Goals now and his colleagues in the not now this minute, but now it's been raised with you? Will you now have a proper discussion and interview with Mr Goals and with the other potential witnesses?
Yes, we will meet with Mr Goals.
And the witnesses who put their hands up in the public gallery here, you'll speak to them and take proper statements from them?
Yes.
Very briefly on communication.
Well, hang on. Let's all not talk about... So we've noted that, and we'll take that one, certainly. John, did you want to come in?
Well, we're at risk of repeating the same point, but very simply, the election court judgment was passed, and we understood that the whole of that judgment, which I assumed included all the subsidiary papers we passed to the Met, and I sort of took some pity on them because there were thousands of pages of it, but I assumed that it would just be a question of looking at the seven findings against the previous mayor and others. But it would also be looking beneath the surface at the various other offences which it was suggested had been carried out. And I come away from this wondering whether that was ever really done, because Mr Goals has illustrated that point.
As a matter of fact, it's important to note that there were 27 files, Lever Arch files, all of which were in the hands of the DPP. And the purpose of the DPP being represented by counsel, which, as Mr Vamos said, they were, was in order to assess that evidence. So the Met had at its disposal from the outset 27 Lever Arch files, all of which were referred to, not directly, but they were referred to in submissions, and they were referred to by the Commissioner in his judgment. So it is not right to say that the Met needed to seek those. They didn't.
So Mr Cundy, has the police got those files, and has somebody read them?
I'll give the short answer to that is those files, as Mr Hall said, went to the DPP. We've not had any referrals from that hearing.
So you haven't had those 27 files?
They went to the DPP, Mr Dismal.
But they haven't come to you?
No, they're with the DPP.
Right. So Mr Vamos, CPS, why weren't those files given to the police?
I would need to go and check what happened to those files.
I mean, this is all Inspector Clouseau, isn't it? I mean,
Paul, Sir Ken, you've been patiently... Hang on. Sir Ken's been patiently waiting to come
Thank you,
in.
Chairman, and good afternoon to your members. And thank you for the invitation for inviting me. You'll understand that as the lead commissioner in the directions put in place, this is not directly my responsibility, but I have made strong observations publicly and had good conversations with, of course, the Mayor and those interested and indeed the Met. Just to go back, if I might, for 30 seconds, you'll know that it's very unusual, thankfully, for a council to be needed to put into directions by any government, and it's not done lightly. And it's not done lightly because it slightly flies in the face of democracy, of the people who voted, therefore they've got what they deserved. In this case, I think, and in each case, of course, a government in those cases puts in a very robust inspection regime. There are only 2 councils that currently are under direction that have commissioners for very different reasons. One is Rotherham and one is Tower Hamlets. And my role, of course, is there to not only see through the specific directions, which are quite different from Rotherham, of course, but also to work with the Mayor and to return Tower Hamlets to the proper home of proper local democracy in London and take its place as a respected London borough. If I could just say as a preface, therefore, that I'm going to say about this part, what I found was anything but that. And the challenge I took in December 2014 was a shock even to me to find that there was an organisation that was supposed to be a local authority but actually was full of secrets and transparency and not trusted internally, even elected members within the council, would you believe, having to put in Freedom of Information Act requests within their council for information about their council, a mayor who actually refused to stand up and speak at scrutiny because he said it was against his human rights to do so, so never did answer questions at his own scrutiny committee. And I was delighted to therefore, and us having in that period having to take out further directions because of we got no cooperation in those early days. I'm pleased to counter that by saying that since the new mayor has been, not very new now of course, but properly elected, we've been able to reduce some of those directions. And I come on to that. But let me just talk, if I may, quickly, Chairman, how we got involved. One of the issues that I found ourselves embroiled in was taking information from whistleblowers, both inside and outside the organisation, who felt that they couldn't trust the procedures within Tower Hamlets and came to commissioners, which was good, but not our main role, to talk about some of the information talked about before and felt that their justice hadn't been seen to be done and they weren't being heard properly and yet had a voice to say. We had throughout the process a good communication point with the Met, and AC King, Helen King, was appointed as that point of contact, not just on electoral fraud, but there were a range of other issues that were going on in the background. In fact, one of those you'll know was, and we've touched on it, was about the very point about grants being given, and only in the last month have I given back chairing that Transparency Grants Committee back to the elected mayor, but prior to the Commission's arrival there was nothing transparent and nothing open about giving grants at all, and I was pleased to make it a very open and transparent process. But there is some confusion, Chairman, and I'd just like to touch on that and how we became concerned. One, about the whistleblowers telling us things that were going on and the conversation we had. This is purely a professional observation as a commissioner that we found in place. First of all, you'll know that the Morey hearing also had in its first instance allegations against the returning officer, which the petitioners dropped on the first day of the hearing. But in discussion with Helen King, we found that all of the evidence that were against the returning officer, that nevertheless were about corruption in the election, were not, we were advised by the AC that no new interviews were undertaken with those people. Those interview statements were dropped and not revisited because they weren't in Morey. And so we felt there was evidence in there that might have been worth looking at again, even though they may not have appeared in Morey as a judgment. I think the confusion that we've talked about, and I well remember the discussion with AC King where that confusion occurred, and I recall it occurring. And it happened this way, because the first, and the Met will know this, the first press release by the Met after deciding to take no action was that the CPS decision was to take no action. When we further had that discussion with AC King, as the CPS have quite rightly clarified at that meeting after some confusion, the cases were never formally referred to the CPS, and they didn't need to. But we still had a feel about the public interest in all of this, in terms of democracy and openness. And the reverse, of course, it being prayed in aid because of lack of CPS action, that is defence that actually it was an establishment that was getting rid of the ex-mayor. I have one of my roles as lead commissioner, My background, of course, is a firefighter, and there's something relevant about that, I guess. But my role is also to have a liaison, not only with the elected mayor and with lead members, but obviously with key players, including the government officials, the minister, and of course with the two MPs. And I was taken by the letter to one of those MPs from the DPP, in which she says electoral malpractice is not always captured under that particular legislation of the Representation of the People's Act and may be best reflected as offences of corruption, bribery and conspiracy, where no time limit applies for bringing charges to these offences. I might have added to that in my innocence, misconduct in public office and perjury, of course. But I think she makes a very good point as the DPP. And I worried slightly today, Chairman, I come back to Mr Duval's questions, which I think were absolutely right, that the offences for me as an observer, and a very keen observer now, and brought up to speed very quickly, are not about offences on the day of election. It strikes me that elections are not just stolen on the day. They can be stolen before by what happens. And I think it's well to, I can well reflect, probably not today, Chairman. I'm happy to come back another time and tell you what's changed in elections from 14 to the elections that happened in 15. A considerable amount did change, including with close work of the Electoral Commission, by the way, and the Met Police, and some really different procedures. But I think my focus has been what happened before the election, around the election, not just on election day, on election day when the election was democratically stolen from the proper democratic control. And I hope that clarifies the Commission's position.
I think did AC King was it, say that she was now going to ask the police to look at this whole issue of bribery and all these other things as well, or was your impression that it simply just left?
No, it was one of the letters that I was interested, because I'd made a public say for myself, as you recall, in a letter to the Mayor and the Secretary of State, that I felt it felt like justice denied to the community, and I was just feeling that from the complaints that I was getting. And amongst those 45 various letters that have gone to the Met from MPs, from myself, from councillors, from MPs, those sort of observations, the DPP did not propose a solution to that. But I think she made the telling point for me that the RPA, the Representation of the People's Act, clearly is time limited and gone, but there are other offences that are not time limited and have not gone.
Yeah. So are the police looking at these things now?
So there are a number of other matters that are not RPA, as Ken has explained, which we have already investigated.
Finished investigating?
So there are a number of other investigations. And this is things that extend from that. So we're
are they ongoing or are they finished?
So the most significant ones are concluded.
Right.
Okay. One of the challenges, and Sir Ken has referred to it, when it comes to we looked at grant allocations in relation to youth services, which was a particular issue which was raised from PricewaterhouseCoopers from their best value audit. That investigation did not establish sufficient evidence to charge any.
But you haven't seen these 17 Lever Arch files, have you?
Sorry, which 17?
27 rather.
From the judgment.
The 27 Lever Arch files that the DPP stroke CPS have got, they haven't given to you to look at.
No, as I said earlier.
We know that. We know. So it's pretty clear that you may have come to an end of your extant investigations, but there is the files. You're going to interview Councillor Gold, and there's other discussions to take place. Now, we need to move this on. Caroline, have you got some questions?
I just wanted to pick up with Francis Hall, because, you know, you're listening to this, and we've read, and thank you, Councillor Gold, for this fantastic letter. So much in here, but as an ordinary person, you think, well, justice needs to be done. There's clearly evidence there, you've got address, you've got whatever, and yet we haven't seen these prosecutions. So I wonder whether, as a barrister, you can explain to us how the burden of proof differs between that which is sufficient in an election court and that needed for a conviction in criminal court, particularly when Judge Murray made it clear he used the criminal burden of proof for his findings.
Identified, because the answer to that is no, there isn't a difference. As, to be fair, the police have acknowledged. What the police say, of course, is that hearsay evidence can't be admitted. Of course, the hearsay rules have lax and quite significantly since 2003, the Criminal Justice Act 2003, but they were always rules, as I said, in relation to bribery. It's always been the case that business hearsay, i.e. documentary evidence, has always been admissible in a criminal court. And that's why I really wanted to identify between paragraphs 460 and 512, I think, of the judgment. A lot of what has gone into there is Ofcom judgments, advertisements, all admissible, evidence of grants, that is admissible documentary evidence in relation to grants, admissible documentary evidence in relation to meetings that occurred, of course, councillors who were at the meetings who can affirm the minutes that took place there, and, of course, the evidence of Deborah Cohen, which I go back to saying, evidence substantiated by contemporaneous notes, evidence of 2 meetings, both of which were denied, as in not just I don't remember this happening, but Alibor Chowdhury, Mr. Assad and Mr. Rahman saying they did not occur. And apparently the police have reached the decision, which again you might be interested in, that doesn't amount to a reasonable prospect of success in relation to perjury, which I think is the answer we got from Commissioner Commander Cundy just now. But that goes to 2 different types of offences. One, bribery, and the Commissioner, of course, outlined in detail the evidence that he took into account. And, of course, bribery doesn't require evidence that somebody has actually been bribed. It is simply an offence of intent. So providing that steps are taken by somebody in order to bribe, in the criminal law, that is sufficient if the intent is there. So in terms of what the criminal law is and what the election law is, of course, the election offences that were established were all criminal offences. But in addition to that, there's the 2010 Bribery Act. And the Commissioner went into detail as to why the 2010 Bribery Act would be met by the evidence that he considered, in addition to the Representation of the People Act offence. And of course, it's of public, it's a matter of public record that Lord Justice Lloyd Jones and Mr. Justice Upstone in the Divisional Court rejected, in fact, not only rejected the application for judicial review, but by rejecting the application for permission, they found it was not arguable that the Commissioner had made an error of law or had made findings of fact that weren't substantiated by the evidence in relation to bribery. And they specifically agreed, paragraph 23 onwards of the judgment of the Divisional Court, with Commissioner Morey's finding as to the legal test for bribery in this particular instance. So all of that was, of course, available. That was only available in January 2016, 16, when we had the judgment in the Divisional Court, 26th of January. But of course, Commissioner Morey's judgment was available since the 23rd of April, and the extension was, I think, applied for well before the 1-year time limit was up. If it wasn't applied for in relation to bribery, it could have been. And in any event, you have the 2010 Bribery Act offence.
Okay, fine.
As
So
well.
I think this is fine.
So
You know,
the
again,
level
we're
of
not the court of law, but that was useful. But I'm conscious as we're moving into the 4th hour, and I don't want to lose anybody.
Absolutely.
Just to say, so the evidence obviously was very strong from the court case, but also, is it possible to turn more hearsay issues into the hard evidence that could stand up in a criminal court?
I think the question in terms of the bribery is what evidence of hearsay do you need? Effectively,
some of the other sort of other evidence that was given, or softer stuff, things that people have said, is it possible to turn that into the hard evidence? Could the Met have done that following this court case with some of the other issues that were raised?
If you read those paragraphs, there's very little reference indeed to evidence of individuals, either witness statements of people who didn't give evidence in court or other evidence that would count as hearsay which wouldn't be admissible in a criminal court. The vast majority of the evidence referred to in those paragraphs is documentary evidence which is admissible in a criminal context, and the evidence of a senior officer in the organisation who gave evidence in the election court proceedings, and there's no reason to think wouldn't be prepared to give evidence. And of course, when it comes to witnesses, an important consideration too is witnesses who are unwilling to give evidence can be summoned. And indeed, we had to summons, the petitioners had to summons a number of witnesses successfully, in the election court proceedings, and those powers, of course, exist in a criminal context too.
Okay, Met, you wanted to respond to that. So there's clearly strong evidence that could have been taken forward in a criminal court. Why wasn't it?
So two comments from myself, if I may. You know, what Mr. Hoare has described isn't so. Firstly, burden of proof, absolutely. You know, it's exactly the same as it is from a criminal proceedings perspective. There is a difference between the evidence that is available, which is what His Honour Judge Moore has explained in his judgment, and the evidence that he heard from individuals, between sufficiency of evidence with which to seek a CPS decision to charge. And I'm not going to get into individual case circumstances. It would be wholly inappropriate for me for reasons which you all understand. But the allegations that Ms. Hoare has gone through were fully investigated. There are reasons why there is insufficiency of evidence from a criminal perspective.
Okay. Mr. Vamos wants to respond as well, no doubt.
Yes, I just wanted to make 3 points, and obviously I'm not going to get into individual cases either. Yes, very, very brief. Of course, Mr. Hoare is correct that hearsay is admissible in a criminal trial, but it's equally correct as a general proposition that the civil rules of evidence make far more evidence admissible in an election petition than they ever would in a criminal trial. So it's a question of looking at each individual piece of evidence and deciding whether it will be admissible. Second point is you can't summon somebody until you've actually commenced proceedings. So if somebody's not willing to give a statement which would enable you to charge somebody, there's really no coercive measures you could use to force them to provide evidence. Final point, and I'm not going to argue with Mr. Hoare about the details of the judgment, but Commissioner Morey himself gives a very good example at paragraphs 338 to 341 of why he was able to draw inferences with his inquisitorial role that would not be available to a criminal jury to find on a criminal standard. So it's not a question of the burden and standard of proof, it's a question of the ability to draw inferences and the different roles in the court.
As in relation to Councillor Shahid Ali, who the Commissioner
Mr. Hoare,
said,
this is not a courtroom,
but that was
and I
very
haven't
much
called
in
you anyway.
context. That
Right,
was the context.
Keith, you got some questions?
I did have some questions, most of which seem to have been asked during the process. However, there was a couple I'd like to ask. Firstly, this is of the CPS and of the MPS as well. We've heard a lot, and I'm sure when you came here today you had a view on this, but I'd like to ask you, in view of what you've heard today, I'll start with Commander Kunde, I suppose, what lessons do you think can be learnt from this case?
So I think the main one which I explained right at the very start, and I think Councillor Golds and what he eloquently put before us today, I think is a good example of that. I think having come with a fresh pair of eyes and looked in it, from the commencement of the investigations all the way through to the present day, that is, and what you see in a lot of things, it's about that communication, that engagement to explain things. Now there are procedure rules which Mr. Vamos has just so eloquently put, which we have to work within. But there's definitely the lessons around that engagement. As Sir Ken has already referred to, lessons from the May 2014 elections in Tower Hamlets were learned quite quickly to evolve and develop our collective response to election day for 2015. And indeed, we are already, and there was a planning meeting later this month to plan ahead to May 2018. So there's undoubtedly been lessons that have been learnt there. From an internal policing perspective, and it was touched on a few times in some of that last discussion, it's not all about electoral fraud offences. It's not all about the RPA, as we've all acknowledged. There are other offences which the MPS has investigated through other specialist officers, fraud investigators, and the like. And there is always the need to take that step back and think beyond the, a member of the public who makes an allegation does not know the law. They will say, this has happened, I think it's this offence. You then rely on investigators with their knowledge and experience and specialist lawyers to say, well, actually, there are other offences which you can consider. And that's what we endeavour to do throughout the life of all the investigations. But I think that is a key thing looking ahead to any other election. Yes, there's about events on the day, particular things around RPA, but it is taking that broader step back as well.
Okay, thank you. And Mr. Vamos.
Well, I can well understand from the outside somebody looking at Mr. Morey QC's judgment and then seeing no prosecutions would fail to understand how those two situations can be reconciled.
I think that's very astute of you to make that observation.
I completely understand that public perception, but the CPS can only follow the evidence and apply the law as it stands. And as a result of the investigation that the Met conducted, which we were involved throughout...
I do apologise for interrupting.
Yeah.
I'm not asking you to justify...
No, I know. So
the lesson that we're in. I'm asking you to... what are the lessons that you've learned?
Sorry.
If any.
I should have got straight to it.
Please,
I apologise. The lessons learned are, I think, about engaging with the stakeholders in this process and explaining as far as possible within the confines of the law how decisions have been reached or our role in decisions made by the Met. And obviously there was confusion about who the decision maker was, which was unhelpful. And so the main lesson for us, I think, is, as Commander Cundy said, it is about engagement and being open and transparent as possible as far as the law permits.
But in your opinion at this moment in time, you don't see anything wrong with the process as it has been, and that there's no lessons to be learnt in improving how the process is?
Well,
only the fact that you didn't communicate how accurately you followed the process.
I can't talk about individual decisions that we made or advice that we gave and whether, in hindsight, we should have given different advice. I can only talk about the process as a whole, and there was a thorough investigation which we advised upon, and we made decisions following the evidence based on the law.
Right, that's very helpful. Thank you.
I think Mayor Biggs wants to come in on that.
Again, you see, I'm just trying to put my finger on where the frustration lies in this, and I do understand the points that are being made, but I think as far as a lot of people are concerned, including a lot of people in this chamber today, the electoral court judge was very clear that there were 19 people who, in his view, were unlawfully elected. There was the mayor plus 18 councillors. Of those, the mayor and one councillor were disqualified because they were named on the petition. The other 17 weren't named on the petition. Nothing happened to them. Of those 17, one went to jail because he was found to be guilty of other criminal offences. So there are 16 councillors in the town as council chamber collecting their expenses, participating in decisions, who haven't really been held to account for anything. Now, some of them are fairly contrite and they recognise that things were wrong. But I guess there was an expectation that if the party that they were elected under was an improper organisation, as the judge said, that it wasn't properly registered, it didn't do things properly, then something further should have happened. And I appreciate all the constraints, but there are 27 lever arch files or whatever it is. There's lots of information about what people did or didn't do. And although it's very time consuming, I think there is a public interest in terms of understanding, learning from that, and holding people to account, and making sure that we learn lessons about how a system which is generally based on trust may need to be better regulated in the event that other instances like this occur. That's sort of
I think that sums it up. Right, Keith.
Thank you. This question has already been asked of Commander Cundy, but I'd like to ask this question of Robin Merritt, and bearing in mind, of course, you haven't had a lot of time to prepare, but you will be aware, I'm sure, that the Deputy Mayor for Policing and Crime said in her letter to this committee that the Met has been both robust and proactive in this investigation. Would you have any idea how MOPAC reached that conclusion?
Well, not specifically to that letter dated the 21st of December, no, but I'm fair to say that kind of the conversations and inquiries that I've been able to make since I started to be involved in this has certainly given me nothing to doubt the quality of the investigation.
So are you saying that, having heard what you've heard today in this meeting here, that you still believe that the Met has been both robust and proactive in this investigation?
When taken in the round with the other information I know, yes, I am.
What, the fact that they haven't interviewed people, they haven't taken witness statements, they haven't investigated 17 plus councillors who are not actually eligible, the fact that they have not followed through a raft of other evidence that Mr Hoare has pointed, you still believe that their investigation was both robust and proactive? Oh, and the fact they haven't been given and looked at 27 lever arch files.
When you take everything in the round, so I don't accept the statements you just made in your question. If you listen to the evidence in the round, And taking in mind the fact that I've done inquiries outside this meeting, yes, my position remains that.
That's incredible. Thank you. Finally, sorry, I'd like to ask of you, Mr. Merritt, how was the Met held to account following Morey's judgment?
There certainly were conversations between the Deputy Mayor and the Commissioner over this matter, the exact detail of which I wasn't privy to. But certainly there were conversations between the Deputy Mayor at that time and the Commissioner regarding these matters, and maybe other senior officers.
And that's what you believe, that's how you believe they were held to account? And that's fine, because if you weren't there, you don't know. Yeah. Okay, thank you.
Were they minuted?
I don't know, to be honest.
If they were minuted, can we see the minutes?
I think it's unlikely, to be honest, that nature.
If you could confirm that, that would be important. But we've got to...
And if it was, can we see the minutes,
yes,
please?
that was the point we made. We've already heard from Sir Ken, but do you want some questions to the Commission?
Yeah.
I want to ask Sir Ken and Mayor Biggs, what has been the result of there not being a prosecution, that there hasn't been collusion in some way or another, not not to bring a prosecution? When I first raised this matter more than a year ago with the previous mayor, I suggested that maybe a reason that there hadn't been a prosecution possibly was the Rotherham syndrome, where a prosecution may have been misinterpreted, or there may have been fear of bringing a prosecution because of community reaction. And so I want to ask Mayor Biggs and the Commissioner, what do they think in Tower Hamlets about the fact that there has been no closure, that there has not been a prosecution? Do residents perhaps think that some people have got away with things simply because the police and the CPS have decided not to take the matter further? I have to say, if I may in passing, refer back to the point that I made earlier. It's the first we've ever heard that there were these extensive conversations between the CPS and the police as to whether or not a prosecution should be brought. We always thought that evidence was presented to the CPS and the CPS decided whether or not there was a case to go on. From what we've heard today, it looks as though both of you have decided that there wasn't anything to go on, and so well, that really gives rise to my question. What do the residents of Tower Hamlets think about this?
Well, there's no such thing as the residents of Tower Hamlets with a single view, obviously.
Of course.
There are quite a lot of people who feel dissatisfied, I think, people who are active citizens in the borough who feel that something went wrong, and very few people have been held to account for it, as I've said already. There is some frustration, and I share some of this, about the competence and willingness of the police to investigate matters, and that's not because, in my view, they are politically correct or sensitive to cultural sensitivities. It's because it wasn't adequately, thoroughly prioritised and investigated, in my view. There's a question of whether there should be some review, and I know I've had this conversation with you at the weekend, Mr. Arbour, whether there should be some review of the way in which the Met Police investigated this. And I think this was first put in my mind by the Commissioners, and I'm sure that Sir Ken will speak in a minute about the possibility of referring this matter to the HMIC. I've discussed that with the Deputy Mayor for Policing as well. I know that she's minded that that's not an appropriate action. I'm not persuaded that it's not an appropriate action. I think that there is merit in looking, this is a public interest, at the thoroughness with which this very sensitive matter was investigated. There's another attribute of this, which is that some of the people around the former mayor have used the absence of prosecutions, and this doesn't mean there should be a prosecution without evidence, as evidence that nothing was actually wrong. So there's a fairly steady sort of rumour in bits of the Townlets community that says, well, no one's gone to jail, no one's been prosecuted, and therefore this was just some sort of political conspiracy with sort of racist overtones. And I think that strays so far away from the evidence that I think there's a public interest in just emphasising that people were properly held to account to some degree for this, but there's a lot of unfinished business there.
Yes, thank you, Mr. Arbour. Chairman, I entirely agree with that. I think it is of two halves. That there in some aspects, not just the physical change the directors required, but underpinning that is a cultural change within the whole of Tower Hamlets and officer level particularly. the culture has changed of trust and openness and one of transparency. And I think anything that can continue to encourage that journey would be tremendously helpful, because there are some that still are in denial, and some would see it slipping backwards in one that's one of secrecy and corruption, frankly, some of which I found in my grants-making procedures and background. So I think there's very clear messages about what's right in local government more generally, and I think there is a very keen public interest in doing so across the whole of London. So I think it's very clear about messaging. And I know that those that I've spoken to in whistleblowing, I mean, the whistleblowing has been really important, because not only has Mayor Biggs now completely updated, refreshed and changed the whistleblowing policy, which I very much welcome, but actually has a team in at the moment looking specific areas, which was over a period, to take through those issues where those outside still did not trust the organisation inside, even though we'd appointed a new statutory officers. And that procedure, I think, is bearing fruit, but anything that damages the implications that it's not a trustworthy organisation, and actually the mayor was somehow wronged, the ex-mayor was somehow wronged, and therefore there was no police prosecution. It has not been helpful. Now, the point that Mayor Biggs raised is fair. I am aware, as you no doubt are Chair, that police and crime commissioners can commission HMIC to look at specific areas in their police force, and do so. They've done so in a number of other police forces. And in the case of London, of course, the Deputy Mayor for Policing has the remit and power of the PCC. So that is an avenue open to the Deputy Mayor for Policing if she so wishes to take that view.
Mr Chairman, there's one more effect that's quite important to note of the fact that Mr Rahman hasn't been prosecuted, which is that he's made an application to the Divisional Court to have his disqualifications removed because he hasn't been prosecuted, arguing that that should be treated like an acquittal in a criminal court. That is obviously a matter of sub judice. It hasn't been determined. He hasn't got permission yet, but that is the application he's made as a result. I think you're aware of that, Mr Chairman, as a result directly of not being prosecuted.
That's very helpful. I'm losing members. Before I finish with one or two final questions, Len, did you want to come in at all?
Yes, please. Can we now go back to that proactive review that you did after? I was quite taken by that. I'm going to look at the transcript a bit more closely. Would it be fair for me to come away from this meeting and say that review may be somewhat limited if it didn't check the files that were available to the DPP?
No, we wouldn't know if it was going to be limited until we know what other information is available, I think would be the answer. So the short answer is yes, a review is always going to be limited if it doesn't look at other material that is then there.
So what's best practice?
But if I may, those files that we received from the judgment which went through to the DPP, my understanding is that they were fully considered, and there were then there are no referrals from that into the
but there were no referrals from the Moray Committee, but you set up a review because you were quite keen to tell me that you were being proactive and following up. Would it not be fair for me to ask you why you weren't proactive in seeking out the files from the DPP in the same vein that you sought to do some work from the Moray thing that you weren't asked to? I welcome you doing the work, because I think that's what proactive policing is about and prevention is about, and doing that work.
Yeah. So the files that came out of the judgment are with the DPP, who had a counsel sitting within court throughout that judgment. The judgment that was publicly available is what we reviewed. Now, we were not required to do that. You know, and as I said earlier, the reason that we did that as the police was because of the nature and the public interest factor surrounding that review. So no, I don't sit here to profess that the review that was done would be a completely exhaustive, looking at every single thing connected to all the events that have gone in Tower Hamlets. You know, and I listened to what Sir Ken has said about holding to account. There are different ways that individuals can be held to account, not just through the criminal process, and that is what the police are here for. It's about criminal investigations. Evidence being available is not the same as sufficiency of evidence for criminal
I think we're looking at the policing activity today, but you're right, the Commissioner himself is aware of holding people to account, because the intervention there was to hold into account local politicians who were doing wrong. in terms of this, what we need to understand around this committee is that did the police do the thorough investigation, as I think as one of your colleagues said in CPS, that we're told that you did. And the evidence in terms of being said here, there's a gap in terms of following through on information that you may have had access to. But let's move on, because I think you've answered that question. Can I just ask, is there, in terms of best practice, who decides to interview whom during an investigation, and who do you say, no, we're not? So in that sense, if someone provides evidence that's quite detailed or not, why isn't that person interviewed at all? Because they're the complainant, they're the potential victim of whatever, or the person bringing the issue. Who decides, and at what level is that decision made? How does that work?
So I think
is there a policy, or...?
There's two aspects I can make. So firstly, a lot of the allegations, referrals that we received will be third-party allegations rather than individual that was party to whatever occurred. You know, the role of investigators as investigating officers is that the investigative decisions rest with those individuals. They will seek advice, they will seek guidance from supervisors, managers, CPS if appropriate, in order to make the best informed decisions. But that's the role of an investigating officer.
Could you accept that making a judgment call then on who you interview could actually skewer an investigation? Could skewer an investigation, or could it not? What's the checks and balances? How do I know that I want to do this?
So that's exactly why we have supervision of investigating officers.
So why,
who can do that, who can provide a check and balance.
I still haven't understood why the level of people, in terms of some of the evidence they were providing, okay, the third party bit I might get, and I don't know the full details, but why were such a number of key people? I mean, I welcome you saying what you're saying and giving the commitment to today to say you're going to see Peter Gold and individuals in the audience, but actually it's something that should have been done some time ago. Someone took a judgment call not to call these people. How does that work? And do you not think that, going away from today, that you might wish to review that, of why you've had to give that commitment to this committee, that a number of people, including Mr Gold, who's quite well known, to be fair, to the police on those issues, that you have to do that?
Not in that respect.
Well, not in that respect. But, you know, do you not feel that that's worthy of a review in terms of the whole issues around that? I mean,
So as was said earlier, so yes, I will speak to Councillor Goals after this, but Councillor Goals was contacted and spoken to a number of times throughout the life of this investigation.
It wasn't. I'm sorry. This is
I've
absolutely... Well, let's have the dates then.
Okay.
Let's have the dates. I
it
was
might
not
not be
spoken to.
helpful, but one of the things that we might want to ask and follow up, Chair, one of the things we might want to follow up is these points, because I think they're quite material, and in terms of the investigations that were carried out. And I need, and I accept what you're saying, but I actually would like to see a bit more substantive information around that. And then finally, I just want to ask, in terms of the background, and you can only answer for your section that's doing this work, but a number of issues, a number of concerns arising from the community is the relationship between the police on the ground as well as their relationship with some of the individuals that were involved in the electoral petition around that. There have been subsequently a number of further police investigations, I think, around youth service fraud, as well as grants. Was there a police investigation into grants, or was there none?
And the grant allegation around youth services. Yes.
Did those investigations fall under your specialist, not electoral team, but your wider issues in the Met, or was that dealt with locally?
So so something that's before I've taken over the post, but the investigation into youth services reported through into Assistant Commissioner King.
Right. So that, and therefore some of your personnel under your command, albeit before you took over, would have been maybe involved in those issues.
So the actual investigators from a different aspect, different part of the MPS are not under my direct my direct responsibility, but are specialist investigators from our Specialist Crime and Operations Business Group.
If I might be helpful, Mr. Duell, the other major issue or major implications was the housing benefit fraud.
Right, okay. So the reason why I'm saying that, there is some wider issues. And I suppose the charge here, and I know the Chair will wrap up, but, you know, the Met has an history of being oversensitive sometimes on dealing with some issues and pulling their punches in internal matters writ large. Do you know what I mean? It's all there in the public if we want to Google it around those issues. I would like for you to provide in some information about those checks and balances that take place that you've said today to this committee about how these processes around who you consult on these investigations and whether in these particular cases you consulted others who you would not normally consult because it's a sensitive, it's a political case. It happens to be Tower Hamlets. It might be those issues around relationships and that what the Met doesn't want to be seen entering into because it's a bit too difficult. How does that work and what do you say to that charge? Because a number of people, not around this table, but some will say it around this table, but others outside will say that the Met didn't do the thorough job that the Met should have done on this particular occasion, and I think there are some other side issues as well. But you're not being asked to account for that today. What do you say to that?
So I'm not quite sure what information you're actually seeking.
Well,
you said providing material, but I'm not quite sure what material you're actually looking for.
Are you sensitised enough to understand that you know that others may have a view that the Met didn't do the full job because it didn't want to upset or it didn't want to enter a political environment, right?
Well, I will sit here and say that is most definitely not the case. Now, clearly, I'm not going to provide a running commentary on individual investigations because you know I simply am not able to do that.
I think it's about checks and balances. I think the point we're making.
But Chair, I'm still not quite clear what is being sought.
It's about political interference.
Yes, it's checks and balances against any temptation to be interfering politically.
Political with a small p,
yes.
Not necessarily a large
Absolutely.
p.
Okay, got that.
Within your organisation.
Okay.
I'm sorry, Chair, but I'm still not clear what is being sought from us.
We might be clearer when we read the transcript and we come back and we'll follow up with some further questions.
The work that's going to happen, and I'll sum up, although I will ask one more question, is that we will go away and consider what we've heard this morning, which is thorough, and we will be doing a separate piece of work to see what recommendation we can make. Now, my last question, because...
Chair, there's one specific question Mr Gold's put to Mr Condy, which is, can you give us the dates when you say you interviewed Mr Golds, because he says he wasn't.
I'm quite aware.
It's a simple question. You've made the point. He said he saw you. We want to see the dates that he saw. Not him personally.
Oddly enough, Andrew, that was going to be part of the summation, because that is there's a patent disagreement here. I don't want it expressed any further, Peter. There's been two different opinions. We will have an expectation that when those meetings were made with the councillor, you can write to tell us when they were. I think that's ultimately very sensible. I don't want to shortchange anyone, but I'm conscious that we're going to be bumped out of here for another meeting in a minute. However, is there anything, particularly perhaps this end of the table, that hasn't been raised that you wanted specifically to see what could have been improved or what can be improved? Mayor?
I'd like to share with you an anecdote, if you like, about the Electoral Commission Code of Conduct, which I'm sure the Electoral Commission would accept is valid, which was during the election, I can't remember which election campaign it was, an activist for one of the political parties was found in possession, I think, of what was alleged to be postal voting material. This appeared to be in breach of the code, which that party has signed up to. I discussed this with the borough police commander at the time, and he said, yep, there seemed to be a clear breach of the code, and the evidence was there. So I said, well, what is the sanction? To which the reply was, well, it's not a policing matter, so the police can't do anything about it. What we need to do is refer it to the leader of the political party for him to carry out disciplinary action within his group. And I think that showed the frailty of the process, if you like. Yeah. And I just wanted to share that with you, because if there is a code of conduct, then it needs to be placed on a more regulated footing, in my opinion.
Okay. I think that's a really helpful... Okay, Pete, I'll give you the last comment.
Very quickly, I mean, we have the next elections next year. 2014, was merely a rerun of what we had seen before. Everything was based around the non-existent, unenforceable code of conduct. Let me read to you what the Rahman people are currently saying. For some, it's not enough that there was a politically motivated stitch-up against him without any proof, beyond hearsay and a witch hunt, as the final decision by the MPS and the CPS clearly showed after their careful and exhaustive investigation. In short, in the run-up to 2018, the MPS and the CPS are going to be effectively co-opted to the Rahman campaign. How will you deal with that?
Now, you don't need to respond to that, but I think it's a point very well made, Councillor. Deputy Chair.
Suggest I read
No,
the report?
got it completely, Peter.
Chair, just 2 points very quickly, just for this to put on record. So the answers that you've given to questions put to you, Commander, and we also have a letter to a solicitor acting for the petitioners, sent very recently, in fact, and the reply is dated the 7th of February, seeking to take a statement from one of the petitioners. I don't know whether there's a correlation between this correspondence and our investigation, but that this is very much a live investigation now.
So it's not about taking a statement, if I can be clear. So as part of the review that I've done, it's clear, and I've been quite upfront throughout this session about the engagement with key individuals, including petitioners, could have been better. So that contact with one of the petitioners was at my request, because it was clear we had not...
Right, but it's very much a live investigation.
No, it's not about a live investigation at all.
No, sorry. I mean, in terms of taking statements from the people who indicated in the gallery, from Councillor Golds and others, that you're not actively pursuing this matter.
No, that's not what I said. We will engage with them to see what evidence they have, to see what we can then assess and see whether we can then do anything with it. That's not quite the same as a live investigation.
Okay, well, whatever phraseology you would use, and I'm going to put it to you directly, maybe more directly to some of my colleagues, that this whole case, I don't expect you to agree with me, is a litany of incompetence and negligence. At the very
well,
least.
I dispute that.
Obviously, we dispute. And finally, Chair, can I also note the sterling work done by the petitioners, the work that other agents were supposed to be doing, and face some considerable legal bills. Thank you.
It's okay.
I just wanted, if I might finally, Chairman, to say that much has changed on the elections on the day issues. And it's something the committee might consider in a wider forum at some point. Firstly, there has been much better engagement with the Met Police and their understanding and training of what's required, not particularly on their own in silos, but actually joint training with the council staff that are involved in those same polling stations, which has been essential. The Electoral Commission, which we've talked about, and that area of exclusion to avoid intimidation from outside. The practice of not allowing other languages other than English to be spoken within the polling station, so it was clear and obvious, and including notices, which is quite within in the law, of course. And indeed, those lessons learned were not only orally given to Sir Eric by myself, but actually we gave written evidence to his review. And whilst I don't accept particularly that one could replicate that in every London Borough polling station, I think on a risk basis it was good to see a police officer in every polling station at recent elections in Tower Hamlets, and the new rules enforced. And I think that bodes well for the future in that joint arrangement.
Yeah, thank you. Okay, that was obviously most helpful. Thank you for your time. Clearly the committee is concerned around this, and really it's our longest session, which is good, and I think it needed that time. I think what's come out loud and clear is in Mayor Biggs's word, the unfinished business. The fact that the good residents of Tower Hamlets many of them don't feel they've had proper closure, and I think this is things that we as a committee be thinking about. We're going to go away, consider what work we need to do, what other information we need from your good selves. But again, I thank you very much for this morning. Very lastly, item 8, can I ask the committee to note our work programme? Today, the next meeting, Thursday, 26th of February. No urgent business. Again, thank you very much.
Chair.
GLA Chamber